to our inquiry meeting on this day, 29th November 2022. Time now is 9:30. Let me take this opportunity to welcome the honorable members of the committee, all five of them here at M46, members on the virtual, members of the public who are joining us from their various platforms, members of the media and the entire support staff. I've excluded evidence leaders, the public protector and the legal team. They are not part of this session. They will join us once the committee is done with its deliberations. So we're meeting as a committee to deliberate on the application that we have received. Yesterday, we cut short our day on an oversight or blind spot that would have occurred that we felt it's important to attend to, even though this is not a court process, to allow the public protector and a team to peruse the response of the evidence leaders. And we would have, as you heard, would have agreed that since the time we concluded yesterday, just after 12, that the public protector team will have time to go through that and make their written submission. I've just been informed that up until this point, until I open this meeting, we have not received a written submission. That's why you would not have received anything as members. But that is not a train smash. What it means is that committee deliberations are continuing. We would have given an opportunity for the public protector team to do that. Have not done that, doesn't stop us from proceeding. We are going to have to deliberate on that recusal application. You would have received a written response from the evidence leaders that I hope that you would have gone through. And we had taken a decision, colleagues, that the response of the evidence leaders was not going to be done oral, because the focus here is not to have evidence leaders being on the stand or on trial and have an inquiry within an inquiry. That's a decision we took. And to start the committee deliberations, I am going to invite our legal services led by Fatima Ibrahim to take us through and sketching the context, but also to place matters on the table here before committee members deliberate, and thereafter. And I'm hoping to give you about 30 or so minutes to do that, and thereafter going to invite members of the committee to engage, and thereafter we'll take a decision as the committee, which will communicate to the public protector and evidence leaders after that. Thank you. You're all welcome. Let me just quickly check before I go to you, Ms. Ibrahim. Honorable Msimang, can you hear us? Honorable Temba Msimang, can you hear us? Honorable Namadzinga, can you hear us?
Ndimarcheroni Chairperson, I can hear you loud and clear.
Sorry, come again.
Ndimarcheroni Chairperson, I can hear you loud and clear. Yes, Chair.
Thank you. All right, thank you, Honorable Chabalala. Before I ask and recognize Ms. Ibrahim, I see a hand of Honorable Mautwe. Honorable Mautwe, you are recognized.
Thank you, Chair. Good morning to you and good morning to everybody. Chair, I just need clarity. I heard you speaking about the application for the recusal. What I thought we were dealing with yesterday was the application for the removal of the evidence leader, not the recusal. So can you please clarify me on that? Thank you.
No, thank you, Honorable Maute. The public protector is applying for the removal or replacement of evidence leaders. So if I have to stand corrected by you, yes, indeed, that's what they have applied for. Thank you, Honorable Maute.
Thank you, Chair.
Thank you. Ms. Fatima Ibrahim.
Thank you, Chair, and good morning to yourself, all the honourable members and the staff as well. Chair, this committee's task is imposed by the Constitution is to make findings on whether Advocate Mkhwebane is incompetent or has misconducted herself, as is being alleged in the motion, so that the Assembly can make that decision on whether or not she should be removed from office. She herself is therefore the subject matter of this inquiry. As previously advised, the committee is undertaking an unprecedented and a novel process. Notwithstanding that Parliament is empowered to conduct this process in terms of Section 194 of the Constitution and the Assembly rules, we do so unfortunately without the luxury of jurisprudence, which we can transplant directly to our scenario to provide us with unequivocal guidance. That is not to say, however, that the committee cannot be guided by what it believes in good faith and on rational grounds to be fair and just, even if this may give rise to a legal challenge. I have therefore advised consistently that the decisions taken by the committee must be circumscribed by the requirements of procedural fairness and substantive rationality. Members would have heard from Advocate Mpofu yesterday that procedural fairness encompasses the rules of natural justice, which entails that there must be no bias and that the PP must be provided with the right to be heard. In addition, the committee's decisions must be rational. In other words, they must be supported by proper reasons and made in accordance with proper processes. They must also importantly be guided by the constitutional context in which we find ourselves, being the duties imposed by the Constitution on this committee, which duties, unless performed and completed before the PP's term of office comes to an end, cannot be said to have been properly fulfilled. In addition, the application of the standard of procedural fairness cannot be divorced from or considered without regard to the unique environment in which Parliament operates and the circumstances created by Section 194 of the Constitution. Parliament, as we know, is a separate arm of government whose members are elected by and accountable to the people. It is constitutionally empowered to determine its own internal proceedings. In addition, the standard of fairness must be considered in the context that the Assembly plays a constitutional function in this matter, which it must do diligently and without delay. In other words, the principles of natural justice are, as pointed out by our courts, flexible in that they hold a variable content, and what may be fair or reasonable in one setting may not be so in another. In determining how to deal with the removal application, this committee therefore must have regard to the sui generis nature of these proceedings and the constitutional duty that the committee is here to discharge. Chair, as you've indicated, the application is styled as a removal and or replacement application, but it has many of the elements of a recusal application, but that is neither here nor there. The application refers to procedural fairness, which I've explained previously in detail and which Advocate Mpofu would have also touched on yesterday, being the rule against bias and the right to be heard. It then also deals with fairness more generally and in a seemingly wider manner than the notion of procedural fairness. And it refers to the duty of fairness of all role players in this process. In respect of that duty of fairness being owed to all persons in the process, I lend my agreement with that, Chair. However, the parameters of what such fairness will entail in the respect of each of those role players, being the PP, the members, the witnesses, the evidence leaders, and the PP's legal team, can only be, and then of course the public importantly, can only be measured against the unique role that each plays in the process. There is a strong element of public interest in this matter, and we must not lose sight of that. In respect of the grounds raised in the removal and replacement application, the application relies on broadly three things. First, misconduct in respect of that dissemination of information relating to the names and fees of various Black counsel and attorneys who have performed work for the PPSA. Second, the misconduct in respect of the alleged cross-examination of Mr. Muntu Sitole by the evidence leaders. And then lastly, misconduct in respect of the preparation of witness statements as alleged. Chair, I don't intend to share any views on the merits of that removal application. Rather, I want to share some general legal principles and practical implications related to it in an attempt to guide the committee. It is the role of members themselves to consider that substance. In respect of legal principles, Chair, I'm going to start firstly with matters related to the substantive portion of the allegations. The first being the dissemination of information on legal fees. In the first instance, I remind the committee that the displaying of names as regards the fees was a direction by the committee in the first instance, and then on the second occasion by the chairperson when the evidence leaders wished to make corrections in terms of the fees that were flighted. As such, it cannot be said to be a decision taken by the evidence leaders who in that instant acted under instruction. In any event, Chair, one of the hallmarks of an open and democratic society is transparency. For this reason, Section 32 of the Constitution guarantees the right of access to information held by the state. Further, Section 217 in relation to public expenditure and procurement requires that when an organ of state contracts for goods and services, it must do so in a manner that is transparent. Our courts have therefore rejected the argument that tender processes, for example, are not administrative action, and that such parties in a public tender process must be distinguished from parties to a private contractual agreement, which would enjoy the benefit of private law prescripts. In addition, Chair, Parliament plays an oversight role over the executive, other organs of state, and all institutions supporting democracy. This oversight role extends to the expenditure of public funds by these entities and is in fact one of the issues that is mentioned in the motion. The PPSA is subject to the Public Finance Management Act, and it reports to Parliament in any event annually on its financial and performance information, so as to allow Parliament to conduct its oversight and determine whether the entity has delivered on its objectives and in accordance with the applicable financial prescripts. The transparency provisions read with the prescripts that Section 59 of the Constitution imposes on Parliament the duty to facilitate public involvement in its legislative and other processes means that the PPSA expenditure is for public consumption. It is an issue on which there must be transparency and accountability. Whilst the constitutional right of access to information is not unfettered and certain information would be protected in terms of PIA or the Protection of Personal Information Act, it is my view that the information displayed was not protected. In any event, this has not been raised as the basis of the objection to the displaying of the fees. Rather, it appears that the two main issues are that the sharing of the information in the first instance contributes to racial insinuation, and secondly, that it's not relevant to the motion. On the issue of racism, Chair, I note that the evidence leaders are accused of being racist towards Black attorneys and counsel, but not towards the PP herself. This is extended, however, if I understood Advocate Mpofu correctly yesterday, by the argument that this conduct is not fair and therefore the PP cannot reasonably be expected to believe that because of that the process itself is fair. The recipients of any unfair treatment occasioned by the directive of the committee to provide details on the names of counsel and attorneys would appear, in my view, to be those very counsel and attorneys who have represented the PPSA and who feel aggrieved and prejudiced in their professional spheres. And in respect of fairness to them, the issues I've raised around transparency of this type of information is important. The question for the committee, however, is whether they agree that a reasonable person in the position of the public protector would, because of this incident relating to the fees, believe that the evidence leaders, who, as I said, were requested by the committee to perform the task, are biased for having carried out that instruction, and that this in turn resulted in an unfairness to the public protector. The committee must evaluate the PP's claims against the context in which that evidence was actually presented in this forum. If that evidence was distorted or represented by third parties, namely the media as it has been cited, or through social media, or used for any other nefarious purposes outside of this committee and outside of the motion, the question is whether that must be attributed to the evidence leaders or not. In other words, who is to blame for the stigma? Chair, as regards the issue of costs versus fees, of which much has been made, and whether this was relevant to the proceedings, members will recall that charge 4 of the motion includes allegations that the public protector failed intentionally or in a grossly negligent manner to manage the internal capacity and resources of management staff, investigators, and outreach officers in the office of the PPSA effectively and efficiently, and that she further failed intentionally or in a grossly negligent manner to prevent fruitless and wasteful and or unauthorized public expenditure in legal costs. The debate seems to turn on what the meaning of legal costs is, and that legal costs does not include legal fees. The Law Insider Legal Dictionary defines legal costs of any person as all reasonable costs and expenses that such person incurs in any legal proceedings or other matter for which such person would be entitled to be reimbursed for its legal costs, including reasonable attorney's fees, court costs, and expenses. The Legal Practice Act also doesn't define fees or costs, but in the context of fees related to charges for services by practitioners, cost there includes fees. The question, however, is a matter that the committee will unpack further, but I'm satisfied myself that legal costs in the motion must logically include legal fees. Importantly as well, the PP's Audi rights are not affected in any way by this information. The PP had the opportunity to extensively cross-examine Mr. van der Merwe, which was the opportunity was taken to do that, and the PP is further going to have the opportunity to present any further evidence to refute any information as regards legal costs or fees, and to explain to this committee, as many other entities do here in Parliament on a daily basis, why that expenditure was reasonable and necessary. This may satisfy and address the concerns of the affected parties. In addition, she can deal again with this in closing. In fact, Chair, we've previously been told that it will be the PP's evidence that she has introduced austerity measures in relation to the issue of legal costs. And at that time, the committee can interact more closely with whether that expenditure complied with the relevant financial prescripts or not. In any event, Chair, I do find it somewhat concerning and difficult to accept the notion that the displaying of a name automatically associates the name with something corrupt or otherwise something sinister, even if it is raised in relation to allegations of fruitless and or wasteful expenditure. A department may, by way of example, irregularly spend money or incur expenses it shouldn't have, but for which a named service provider cannot automatically be attributed blame. This is in fact a common occurrence in Parliament, where we often hear the names of service providers. If this were the case, then Parliament would never be able to permit the names of those service providers being mentioned during our oversight processes. But as I said, we see it all the time. One only needs to attend a meeting of SCOPA to see how these issues are engaged on. In respect of the second issue, which was, I'm going to join the second and third issue, which was the cross-examination and the drafting of the affidavits. Here, Chair, I want to remind the committee of the role that the evidence leaders play. We are all in agreement that they are not prosecutors, and they therefore have no case to put before this committee as a prosecutor does. They are here simply to assist the committee to execute its function by collecting, organizing, and presenting evidence. They do this subject at all times to the committee's direction. The committee can at any time ask the evidence leaders to look for or to search for information different to what has been put forward. They have also been appointed because they are senior and experienced legal practitioners who are trained and obliged to be scrupulously honest. They hold no mandate in respect of assisting this committee to reach a particular finding. In fact, no member here holds a mandate in respect of the committee reaching a particular finding, but rather they seek to ensure that the committee is seized with evidence that is relevant and related to the motion. In addition, Chair, and very importantly, they are not decision makers in this process. Advocate Mpofu yesterday refer to the SCA judgment of Porritt versus the National Director of Public Prosecutions. And that judgment also notes that whilst the judiciary is held to the highest standards of independence and impartiality because they are decision makers in an adversarial judicial system, prosecutors neither make the final decision on whether to acquit or convict, nor on whether evidence is admissible or not. The function is to place before a court what the prosecution considers to be credible evidence relevant to what is alleged to be a crime. Their role excludes any notion of winning or losing. It is to be efficiently performed with an ingrained sense of dignity, the seriousness and the justness of judicial proceedings. These principles, Chair, in my view, help us to understand, at least at a general level, the position of the evidence leaders, with the added nuance that unlike prosecutors who act independently from the judiciary, the evidence leaders here are accountable and answerable to the committee, and they take the instructions and direction from it. Furthermore, unlike the National Director of Prosecutions, the evidence leaders played no part in the formulation of the motion. In other words, if there is anything in the conduct of the evidence leaders that the committee feels gives rise to a bias claim or conduct which has not been performed efficiently with a sense of dignity, seriousness, and justice, which would be expected of the evidence leaders, that then may result in an unfairness. So this is what the committee would need to consider. One of the roles of the evidence leaders is to put any questions to witnesses to assist the committee. This is a function they perform in terms of the terms of reference and the directives. The committee remains always at liberty to put a stop to questioning or when considering the evidence to determine what weight or reliance it will place on that evidence. This, as I've said from the beginning, is not a court process, and the rules of court in respect of the examination of witnesses cannot apply without qualification. Similarly, there is nothing untoward in and of itself in the evidence leaders preparing draft affidavits and assisting witnesses with statements. That is a core part of their function in assisting the committee, and it's a standard legal practice. In fact, members may recall that our call for public participation indicated in the advertisement itself that such assistance would be offered, and it would be offered regardless of whether the evidence that somebody wished to tender was in support of or refutes the motion. Furthermore, the witnesses were required to provide their evidence on oath, precisely so that they could take ownership thereof. In the Nugent Commission, Chair, which the committee will recall was referred to during the testimony of Mr. van Roggenberg, issues there were raised by Mr. Tom Moyani about the role of evidence leaders and counsel in that process. And I thought it would be useful for me to quote this for the committee. I will also ensure that the Secretariat sends you a copy of this particular ruling. There, Chair, in a judgment handed down by Judge Nugent, he stated, I think it is important also to say something about the role of counsel appointed to assist the commission, who also came in for insult in the course of the submissions. While often called evidence leaders, this is a misnomer. The process of a commission of inquiry is inquisitorial, unlike that of a court. This means it must make its own inquiries, seek out evidence itself, and interrogate the veracity of that evidence where that is required. Counsel appointed by a commission facilitates the performance of all those functions under the direction of the commission. When oral evidence is to be heard, it will be presented to the commission by its counsel. Where counsel has no reason to suspect the veracity of the testimony, counsel play their part by guiding the witness through the testimony so as to ensure that the relevant testimony is extracted. Where there is reason to suspect testimony might not be true, they play their part by examining the witness vigorously, if that is required to test its veracity. Indeed, it might be that a witness is called solely for vigorous examination, so as to extract information that the commission requires. And if a witness has given testimony when there has been no reason to suspect it might be false, and it turns out later that that might not be the case, then the witness is liable to be recalled and examined more thoroughly. In short, the approach counsel will take to oral evidence will be dictated by the exigencies of the case. Some cases will require the witness to be guided. Other cases will require the witness to be interrogated, and some cases may require a bit of both. So, Chair, there can be no confusion that the role of evidence leaders is to ensure the veracity of the information that is placed before the committee. They are not here to assert any particular version. In addition, this matter is also distinct from any commission of inquiry, insofar as the PP will be allowed the opportunity to rebut all evidence. That is not always the case in the manner in which other commissions of inquiry are run. Chair, I'm going to move on to some general legal questions and principles that may be helpful for the committee in determining this application. The first is the question of whether the application is premature. The application, as we know, is interlocutory in nature. Whilst there is no question that the PP is within her rights to bring any application or make any request to the committee, there is a question of the ripeness of such requests. The application is premised on unfairness based on the conduct of the evidence leaders and solely in relation to the manner in which they have put evidence before this committee. The committee has, however, yet to deliberate on that evidence or reach any conclusions. It has not reached the stage where it has accepted the evidence of any witness as the undisputed truth. It may be that the very evidence being referred to, that of Samuel, Tajani, and the questions then put to Mr. Sitoli, may not be used to make an adverse finding against the PP and may even be used in favor of the PP. We're not in a position to know that as yet. The weighing of evidence will rightly happen in the context of the vigorous cross-examination, which we've already seen, and with regard to the additional evidence that the PP must still put forward. Furthermore, while some of the complaints against the evidence leaders were canvassed by the PP's team as early as during Mr. Samuel's evidence, where the issue of them drafting the statement was, as I recall, initially raised, this application is inexplicably only brought now. Thus, in addition to the issue of it being premature, because it can be dealt with in the courts, is also the question of why this request didn't come earlier. I noted yesterday that Advocate Mpofu seemed to suggest that they were not invited to make submissions on the recusal application brought by the UDM. Chair, this is incorrect. They were in fact provided with a copy of the submission, and a letter was addressed to them inviting them to make such reps, but they did not avail that opportunity. In any event, I seem to recall that Advocate Mpofu may have said that that recusal application was not related to matters internal to the proceedings. Similarly, Chair, this issue of legal fees was also raised some time before this application, but the committee can decide itself whether there's any significance to the timing, as it should with every single application or challenge during this process. But Chair, I do want to say the piecemeal approach has a knock-on effect on the work of the committee. It results in delays in a process that, as I said, cannot unfortunately be stretched beyond the term of the PP. This is the reality of the situation, and it's not a deadline that I am imposing. It is a deadline that the committee is unfortunately faced with. Again, I assert, whilst the PP has the right to raise her complaints, the committee has to take cognizance of the constitutional context in which it operates, and it must ask whether these smaller applications are appropriate vis-a-vis a review process that can be brought at the end. The rights of the PP, in short, have to be balanced against the constitutional obligations of the committee and the issue of public interest. The next question, Chair, is whether there are any other remedies for the PP. Tied to this question is whether there is prejudice to the PP, and if so, what her remedies would be. As I've indicated, Chair, it's not clear what the prejudice is in the absence of the committee making any findings as yet, and the House making an ultimate decision on the matter. If at that stage where the committee accepts the evidence, which then is in the view of the PP tainted by the evidence leaders, and this results in an adverse finding and removal by the NA, the PP will not be deprived of her right to review the process. But this will then be in relation to the decisions of the committee. And we've already been told that there are numerous instances that have arisen during these proceedings that the PP may well take on a review. The time, therefore, in my view, Chair, is not now. Then, Chair, I want to move on to this issue of public interest and public participation. This is a constitutional process, and the NA is accountable to the public. It must therefore have regard to the fact it represents the South African public in the process, who have a legitimate interest in seeing this process to conclusion. As such, the decision does require some balancing of these rights when assessing the risks of accepting or rejecting the application. Public interest entails that even political decisions must serve the public interest. Public participation, however, Chair, differs in that it relates to the manner in which public involvement in a process is facilitated. In this 194 process, public participation relates to the subject matter of the inquiry, the charges in the motion, and the fact that the public must be kept in the loop, as it were. Public participation must also be reasonable. This is the benchmark. In some cases, it will suffice that the public is allowed to access proceedings by watching it without actively participating in decision-making. An example of this would be when a committee is deciding on its program. In other cases, it is necessary to call for and invite for submissions, the way we do when considering draft legislation. Hence, in this process, we invited the public to provide the committee with information related to the charges, irrespective of whether that information, as I said, supported or refuted the charges. And whilst we allow the public to attend our hearings, we do not allow them, rightly so, to participate in the debates and decisions. That would be a never-ending process. Whilst there is both a public interest and a public participation element in the issue of removal, I am of the view that the latter is limited to accessing the proceedings rather than participation in the proceedings. In other words, Parliament must ensure that the public has access to observing the decision-making that we are going to embark on. If it were the case that the public should be involved in submitting input on how the decision is to be taken, then we should call for public submissions on this interlocutory application and all that have happened so far. I, however, Chair, have no qualms with the committee considering the issue of context, the nature of legal services, and so on, espoused in the letters and submissions received from external counsel and attorneys when it deliberates on the issue related to costs. This is, in fact, important information that the committee must consider. However, Chair, to suggest that the evidence leaders should be removed because of an external third party feeling aggrieved is somewhat problematic, and it does not speak to the administrative fairness issue as it relates to the PP. These matters on a consideration of reasonable and relevance cannot be said to be relevant to the decision, nor does it dilute the fairness requirement. That being said, of course, as I've said, the committee's recommendation at the end of this process and its consideration of the allegation related to costs may full well be influenced by these submissions. The question for today, however, is if and how the information on legal fees is unfair to the PP and is an assault on her right to administrative fairness, and not what others may feel about it. Chair, I want to move on to the practical effect of the application. The evidence leaders were appointed by the committee to assist it in discharging its functions, and therefore any consideration on whether to remove them or must be a decision that's taken by the committee as a whole. And in taking that decision, the committee must consider the impact of the removal on the committee's proceedings and the justification, if any, for their removal, as the removal will whether or not on a clear finding from the committee that the alleged conduct constitutes misconduct and warrants a removal will affect the business of the committee going forward. If the committee decides to remove the evidence leaders, which, as I've said, it's entitled to do, and of which there can be no doubt on that, it will mean that the hearings in all likelihood must start de novo, unless agreement can be reached between the PP's team and the committee on the admissibility of all the evidence we've heard so far. This is because, Chair, every stitch of work done then by the evidence leaders may become tainted in some way or the other by these allegations, notwithstanding that there were only specific scenarios mentioned in this application. At the very least, all of the institutional knowledge then that the evidence leaders have built up over months of work will be lost to the committee. Chair, this application also comes at a critical time. The evidence leaders have presented the evidence of witnesses identified by them, and it is now for the PP to lead her evidence. In addition, the allegations itself in respect of the airing of the legal fees on which much of the application is based appears to be misplaced. but the committee can further consider the explanations in respect of the question of cross-examination and the preparation of witness statements. Removing the evidence leaders at this juncture will no doubt have a severe impact on the budget and the timeline of the committee. And it's almost certain that the committee won't be able then to complete its task before October 2023. This, as I've said many times before, is a constitutional function which must be performed diligently and without delay. The risk for the committee is that if it does not remove the evidence leaders and proceeds, these matters may form part of a later review, depending on how the matter unfolds, or may even be subjected to a review prior to concluding the hearings, as we've seen with the recusal application of the chair, which is currently before the Western Cape High Court. This matter has, Chair, been litigious from its inception, and therefore there's always the risk that the outcome will be challenged by review. The committee, however, cannot be expected to act in fear, but rather it must ensure that any decisions it makes are rational decisions, and the committee must satisfy itself that the right to procedural fairness has not been impaired. The risk of not proceeding is that the committee will not finish the task, as I've said, and that it won't do what it's mandated by the Constitution to do. This, Chair, may give rise to a completely separate set of legal challenges from other interested parties. It thus appears, Chair, that both scenarios, accepting or rejecting the application, will have legal consequences. The committee is to weigh and consider these, and if in its view, the conduct of the evidence leaders have affected the PP's right to natural justice, then it must be satisfied on those grounds that the process has been unfair, and it can then take that decision to remove. If that is the case, Chair, we will advise further on practical steps that the committee may wish to follow, but I'll leave it in your hands. Thank you, Chair.
Thank you, Ms. Tima Ibrahim. You've just taken just less than the 30 minutes I gave you. It's now 10:08. You started at 9:38. So you stuck to your time, which is what I am going to ensure. Thank you, even with the members. Thank you. Colleagues, with that, maybe just before I invite members to engage now, because that's an opportunity for members. The committee secretary would have just sent me something, Tembinkosi, in relation to the submission that would have waited for. And he would have received a WhatsApp message well beyond the 9:30 start of the meeting from the Sianejo attorneys, and the message reads, Tembinkosi, we're doing the best we can do not to have a secretary. We do not have a secretary, so we're typing the response, and we're to consult with Mr. Nyathela last night till late. Please accept our apologies. We will send it by hopefully 10:30. Sincere apologies from the team. I thought I must just give you that. I would have indicated at the beginning that I consider that the fact that there's been no submission, not as a train smash, and that we will proceed with the deliberations. I'm adding that message to that point. It's now opportunity, honorable members, that I invite you to engage.
We engage, Chair. The message that you've just read out from Sianejo, that is their response to the submissions of the evidence leaders. Is that correct?
Remember, we had asked them and gave them the entire afternoon
Yes.
to prepare a written submission. That submission has not been received when I started the meeting. Even as I talk to you now, it is their message to say they will endeavor, hopefully by 10:30, to send that.
Thank you, Chair. That brings me to my point, which is that I think that as a committee, for us to deliberate without having that response in our hands is a little bit problematic. I think that we need to see their response before we actually start engaging with the two submissions. Thank you, Chair.
That's one view, colleagues. What are the other members saying? Because it means you must wait for another 20 minutes to receive that, go through it. We're very clear yesterday. And the directive is clear, and there was enough time to prepare and deliberate on that. What we're not going to allow is to have the committee's work defocused and sidetracked for those kind of issues. And so I'm going to invite members to deliberate on the matters. If that's an issue that they want to raise, you raise that. But I'm now at that point to ask you to engage and deliberate on these matters. I see. So the first hand and member would be Honorable Maute. Who? Let me see who else. Honorable Heron. Honorable Sukas. Honorable Van Minen. Honorable Pondwe. Honorable Milan, in that order. And now followed by Honorable Ngozi. Thank you. We start, Honorable Maute.
No, thank you very much, Chair. Chair, I'm in support of the proposal by Honorable Heron that we wait.
Honorable Heron has not spoken.
He did. He asked that we wait until we receive the response from the PP's legal team. I'm on that point.
It is not Honorable Heron. It is Honorable Kevin Milham.
Oh, okay. Yeah, Chair, I'm saying that I think in all fairness, let's wait for the submission, because otherwise we're going to have to come back to it. We're going to engage now. Of course, we listened to the parliamentary legal service, which act as if they are the opposition of the legal team. I mean, it's in all their submissions, they've always been on the opposite side. So it looks like it's the evidence leader and the parliamentary service that is opposed to the legal team of the public protector. So I think in all fairness, let's wait for it's only 10:15 now. It's 15 minutes to go. So let's wait for it. It don't do any harm. So that when we engage on everything. And Chair, I don't know if what happened to the promise you made for the opportunity to the members to ask clarity seeking questions to the PP's legal team. I don't know where we stand with that. But Chair, I think my submission is that let's get the response from the legal team of PP. They will explain themselves why they're only sending this late now. I think they also need to come to put it on record why they're only submitting to the committee now, way after the deadline. And then we engage on their response, and then we move like that, Chair. I thank you.
Thank you, Honorable Maute. Honorable Heron.
Chair, I don't know whether I want to engage with some of the arguments that were presented now. So there's now two proposals that we wait. So should I wait? Hear what other members say, because if we're going to receive the response and then engage, then I should hold back on my input.
Okay, Thank you, Honorable Heron. You're saying you're ready to, because you want to deliberate on the issues and you don't want to mix the issues, basically. So let me just clear this so that if maybe just to get those members who just want to speak on the proposal I put on the table. I've read the WhatsApp message on record. We have not received the submission. Even now, there's no indication that says we have received that. We would have indicated yesterday we're starting at 9:30. Would have indicated that we needed this either last night or first thing this morning. We don't have that. It's not been sent to us. In fact, the WhatsApp message was a response to an inquiry from our side. It took the committee secretary to ask whether there was when is the submission coming. It's only then that you got a response that says, hopefully by 10:30. It is not an initiative of the team to say we're delaying. We'll send this to you later. It can't work like that, colleagues. We've got to just prevail on all of these what I call incidentals and focus on the main issues that we're here for. And therefore, I'm as correctly, Honorable Heron, so that you don't waste your time, I'm going to put you on hold for now. If there's any other member who can just respond on that issue, I'm putting on the table that we start our deliberations just to get to that, so that we clear that. Honorable Sukas.
I'm sorry, Chair. I just want to ask, are we to respond to the decision or to your comment on deliberations? Chair, I think we need to be mindful of what is our primary mandate here as a committee. And in light of that, it is important for us to focus on what it is our main job to do. So I would support that we do the deliberations.
Thank you, Honorable Sukas.
Yeah.
Honorable Gondo.
Chair, I agree with Honorable Sukas, and I agree with yourself. I think the strength of what they wanted to say is contained in the original application. And so, and we've given them enough time. If they, at this point, my assumption is that they should have long consulted with Mr. Nyathela. So what they should have been doing now is touch-ups and not prepping him from start. So I think we've given them enough time, and we can go ahead and deliberate on the application. And
Okay. Yeah. Thank you, Honorable Gondwe. If there's no other comments, I want to go back to Honorable Heron so that I invite him. Is there any other comment?
Yes.
Okay, I didn't see your hand, Honorable Ngola. Honorable Ngola.
Apologies, Chair. I'm using a different gadget, so I don't see when I should.
No problem. Go ahead.
Chair, I want to submit that it is my conviction that when you said we must receive it not later than 8 a.m., it was because you wanted to give us approximately an hour as members to go through the submission and the response. So even if it arrives at 10:30, members would not have known the contents of the submission, and it would not have assisted us to deliberate properly, having known that submission. So even if it arrives at 10:30, Chair, we still would be incapacitated to deliberate in accordance to what has been submitted, because there would literally be no time for us to go through that submission. So I want to support, Chair, the submission that we must proceed. Thank you very much.
Thank you, Honorable Ngola. Support for us proceeding. Having noted all of those hands, allow me to then go back to the hand of the member who I've put on hold to make his own contributions. Honorable Milam. No, Honorable Heron. I'm doing the same mistake now. My apologies, Honorable Heron. And don't mention the point you were mentioning informally.
Chair, Honorable Chairperson.
Yes, Honorable Maute.
Yeah, I just wanted to find out if the committee is aware that the evidence leader submissions were also late. They were supposed to submit on Saturday. They only submitted on Sunday. So there's a ripple effect. So when we discuss the lateness of the PP's legal team to submit to the committee, we must also talk about the lateness of the evidence leader submissions, because that caused the ripple effect. Even worse, the submissions were not even sent to the PP legal team. So I think let's also be mindful of all that and not paint the picture as if it's only the PP's legal team that is at fault here. It started with the evidence leaders. They must equally be condemned. And I'm saying to you, Chairperson, humbly, it's 10:20. Can we allow the PP's legal team? Let's go for break now. Let's break for tea now and go and come back with the submissions from the PP's legal team. I don't think it will hurt anyone, Chairperson. That's my, I'm humbly requesting you to consider that. Thank you.
Thank you, Honorable Maute. Your reflections are noted. I now proceed to Honorable Heron.
Thank you, Chair. Chair, before I indicate my response to the applications, I want to raise some concerns around, and I have raised it before, the role of the committee. I've indicated before that we are conducting ourselves almost as passive receivers of information, whereas the terms of reference say that the committee shall call witnesses that it identifies. I don't remember us ever having a discussion to identify which witnesses would be called and what evidence we need to be placed before us. So I don't know where the committee's role in actively identifying witnesses and evidence that we need to hear and see has come into the evidence that's led before us. And that leads me to the issue that's before us now, and that's around relevance. And I don't want to get too far into the merits of the matter and the evidence, but the charge is fruitless and wasteful and unauthorized expenditure, which we all understand as parliamentarians has specific meanings in terms of the Public Finance Management Act. The evidence that was presented to us was not presented in any way to further that charge. There was no evidence of fruitless, wasteful, unauthorized expenditure that was presented. And if you read the evidence leaders' response to this application, they convert it into excessive legal costs. And that's a different charge altogether. The charge that's in the charge sheet is fruitless, wasteful, or unauthorized. So I think it is, there's something mischievous in conflating excessive with fruitless and wasteful and unauthorized. And the evidence leaders say in their papers that it's up to the committee to decide. I don't think that this committee can decide fruitless and wasteful or unauthorized expenditure. That's an audit process, and we haven't, and we don't have the capacity to audit. I'm also concerned around, and I think there is an element of truth in the public protector's suggestion that there's a pursuit of sensationalism, because that evidence was sensational, and we have to ask whether it was necessary. And I want to go back to the issue of the evidence that was led by the evidence leaders from Mr. van der Merwe, where he gave evidence about the public protector's bodyguard eating too much KFC. What was the purpose of presenting that evidence to this committee? It has no relevance to the charges. It seemed only to be for the purpose of media sensationalism, because even when I questioned Mr. van der Merwe, he conceded that, and he apologized for the comments, but conceded that the evidence came from a police report. The police are not medical doctors. It didn't say that there was an overeating of KFC. So there's an element here of sensationalism seeking, which I think we must be very cautious about as a committee. This is a very serious matter that we're dealing with, and I'm uncomfortable with the idea that we are courting or appear to be courting public outrage through evidence that is not relevant. I think I've made that point. Advocate Ibrahim also indicates that there's a debate around legal costs versus legal fees. And I think that that may be splitting hairs. The charges are quite clear. There needs to be evidence of fruitless and wasteful or unauthorized expenditure. And so I go back to my first point. We need as a committee to be more active in managing the evidence that has been led, the relevance of the evidence, and what we want to get as a committee in order to make a decision. So in my view, based on the papers, I cannot find that the evidence leaders need to be removed. And so that would be my proposition. I don't think there's a case has been made out that the evidence leaders need to be removed. But I do want to ask that as the chair and as the committee, we are managing more actively what evidence is presented to us and the manner in which it's presented and for what its purpose is. And then finally, I want to ask in that vein, and we can deal with this question later. In terms of the terms of reference, the committee will identify witnesses that it will call and it needs to hear. There's been one witness that I've been waiting to hear evidence from. And it relates to the first charge, which is the Freddie dairy charge. Advocate Cilliers' name has come up over and over and over again as the member of the public protector staff in the Free State who started the Freddie dairy investigation. Why have we not had that evidence? Who has decided not to call Advocate Cilliers? Is she not available? I think we need some explanation, or the committee needs to resolve that evidence, her evidence, is necessary in order for us to make a finding on charge 1. Thank you, Chair.
Thank you, Honorable Heron. Your points are well noted. Maybe just before I proceed to the next member, because there's quite a thin line between the two that, remember, as a committee, we're still going to get into deliberations. So I would ask that we don't even slightly venture into that. And quite clearly, I'm excited about the fact that with this long process, honorable members have been so in touch with every witness and the issues raised. So the thin line, Honorable Heron, is it's almost getting into that when you make that very specific point about at this stage that what has been presented doesn't give you a sense that there's a case for this and so on. I'd like us to stay a little bit away from getting into that point. And I'm saying it's a fine line, so that I don't get the members starting into the merits and making their own before you get into the deliberations yourself, because we're going to get into that point where we declare what, in terms of those 4 charges, this is what I think. So I'm saying it's a fine line, and I might be subject to correction, but okay. Thank you, please.
My point, and I did say up front that I didn't want to get into the merits because I do understand that we will deliberate, but I was really trying to make the point that as a committee, we need to manage the evidence.
I completely get that. Thank you for that. Honorable Sukas.
Thank you, Chair. Chair, my position on the application is, it is clear in all the committees that I serve on, especially health, that those providing services to the state must understand that details of payments they receive can be reviewed in committee and with the public through the work of the committee or the activities of the committee. An example of that would be that in social development, for instance, there has been now twice reports on expenditure relating to the ICT spend of the department. The committee has asked, who are those providers? And what was the amounts allocated in those cases? Employees of the public protector that came before the committee were under cross-examination questioned about their earnings, salaries of R1 million, and the value they offered for that reward. No pay-as-you-earn and personal expenses were asked. Those who wish to be employees of the state or contractors to the state, as is their right, who do not want these matters to be disclosed should place their talents exclusively at the disposal of the private sector, which as its name applies, it is private. But when you are doing business with the state, it's inevitable that becomes a matter of public interest, and also that as part of oversight, that would be revealed or made known. Chair, I think for me, it is important for us to note at the context that we're in terms of the efforts that has been made to delay and stop the proceedings. And if we judge the application, we should also look at the impact of what has previously been before the committee, the treatment of witnesses that came before the committee, harsh, intimidating, threatening, questioning of witnesses. Threats were made to their livelihoods. This came before this committee. And I think the committee has, as far as is possible, ensured that the processes and procedures are fair to the public protector. I think it is Honorable Heron that in the beginning of, as said, that what is at stake and why it is so important for us to be fair and be without bias, and the committee has stayed within that. However, we cannot be consistently delayed in what is our work. It is not the evidence leaders that are before us. It is the public of South Africa and this committee, and myself as a member, that needs to hear the public protector in a role as the public protector to answer to this committee, not the evidence leaders. And I strongly feel that we need to pursue our mandate, because we would fail if we do not complete this process. And it is our public duty to do so. And we cannot be hamstrung by this. It doesn't serve the ultimate goal of the committee for us to consistently be derailed in the manner that we do. We need to, as Honorable Heron has said, the issue of relevance, the issue of relevance as to the work that we do certainly must be our main consideration. And therefore we need to proceed, Chair, and the evidence leaders, as has been said, they are here to serve and assist the committee. It is for the committee to deliberate and look at the evidence that was put before it. Thank you.
Thank you, Honorable Sukas. I now recognize Honorable Benedicta van Minen.
Thank you very much, Chair. I want to agree very much with what Honourable Sukas has just been saying. And I think it's also important at the outset to note that all parties to this parliamentary committee have agency. Senego has known about the timeline. They knew that the witness was due to start yesterday. They knew about these applications. I'm afraid I do find a rather unilateral informing of the committee that they're only going to be, submitting documents after 10:30 to be most unfortunate. It certainly doesn't assist us in this process. But I think what I really, at this particular point, want to raise is that this is a Section 9 institution. It is directly accountable to Parliament. I also sit on SCOPA, and what we do is we go through balance sheets, we go through finances, we go through audits, and I think it is very important that this committee, in fact, has sight of spend. I think it is a very vital part of what we're engaged with. And as such, I think that this application does need to be rejected. I think going forward, we need to do our jobs and do it properly. And we can't say that there are certain aspects of the inquiry we're not going to enter into when it very much falls into our mandate. And it also falls to the duty of the public protector to report to Parliament. And that is squarely within this ambit. Thank you very much.
Thank you, Honorable Van Minen. Honorable Gondwe.
Thank you very much, Chairperson. Chairperson, it concerns me that time and again, as a committee, we are being requested by Advocate Mkhwebane and her legal team to shift or divert our focus from the mandate of this committee and the business of this committee and focus on applications that really, in my opinion, have no bearing or relevance to the mandate of this committee. And these applications, Chairperson, are in essence repeated and concerted efforts or attempts to stall and delay the committee from concluding its work before October next year. We have to tell it like it is. Chairperson, this application, much like preceding applications, is another veiled attempt to stall or delay the committee from reaching its conclusion and holding Advocate Mkhwebane accountable. And we must not let this application and any other subsequent application that will be brought, because I have a feeling this is not the first time and it's not the last time. In fact, I have it, you know, we all know this isn't the first time, but it's definitely not the last time. And it brings it to a total of 6 applications. If we include the walkout, that in my opinion was staged, and we still have no explanation as to what happened on that day. It brings it to 6 attempts since the commencement of this inquiry, 6 attempts to stall the work of this committee. And it's really concerning, Chairperson. And like I said, we should not divert our attention, our focus from the mandate of this committee. And these applications are being brought in a piecemeal fashion, and they are repeated, and as Honorable Suka has indicated, they're consistent, and they're all simply aimed at stalling our work and delaying the work that we have to do as a committee. Chairperson, we have to hold her accountable, and no one must stop us from doing that until such a time we have a court order or an interdict that prevents us from doing our work. Let's carry on doing our work. Chairperson, and members of this committee are intelligent people, competent people, and that's why we've been deployed to this committee. And if we had a problem with the evidence leaders, if we had noted any form of misconduct on their part, we would have, stopped the proceedings and requested that they be, removed and be replaced. But in my opinion, they've done nothing that can suggest that, they're misconducting themselves in any way. If anybody has been misconducting himself in this committee, it's Advocate Mpofu. And Chairperson, can we get feedback on our requests that he be investigated, for the utterances that he made? I can't remember the date of the meeting, but where he threatened you. And yesterday we also witnessed a form of misconduct on his part, where he was defying your instruction to keep quiet and allow you to take over this, to take control of this meeting. Thank you very much, Chairperson.
Thank you, Honorable Gondwe. And now recognize Honorable Milam.
Thank you, Chairperson. Chairperson, I want to align myself with previous speakers who have indicated that the process that is being followed by the Public Protector's legal team is one of stalling tactics. It's one of attempting to derail the proceedings of this committee, and is simply a matter for argument in court or at a later stage. But we can't, as a committee, allow this to prevent us from doing our work. One of the issues that I have is the complete disrespect for parliamentary process that has arisen in this hearing. In particular, Chairperson, the fact that members of Parliament are entitled to ask questions of witnesses, are entitled to seek clarity, are entitled in terms of the Powers, Privileges and Immunities of Parliament Act to basically ask or say anything without reprimand from people who appear before the committee. The only person who actually can say that is you. You have control of the meeting, and you can call us to order, but certainly people appearing before the committee cannot do so. Chairperson, I feel that the application that we are considering today is yet another frivolous application. It is one that is designed to waste time. I think that as far as the evidence leaders are concerned, the way they have conducted themselves has been beyond reproach, and that they have conducted themselves in a manner that is fair and impartial, that they have not sought to influence the thinking of the committee. They have put the evidence that has been required or requested. I do agree with Honourable Heron that there is additional evidence that could be brought before the committee, and that there are additional witnesses that could have been brought. But I don't think that we can accuse the evidence leaders of having been biased or having been racist or having been in any way or having in any way misconducted themselves in the process of this hearing. So, Chairperson, I want to say that I think that this application should be dismissed. Thank you, Chair.
Thank you, Honorable Milam. I now recognize Honorable Bekiz Wengosi.
Thank you, Chairperson. I do have some unstable connectivity issues, so if I break, my apologies.
Okay, thank you.
Thanks. Chair, I just want to start by saying that yesterday, the committee allowed the PP legal team ample time to consider the responses of the evidence leaders. And I don't think that ordinarily we would have done that had we not recognized the fact that the glitch or the mistake happened on our side, and therefore the need to provide the PP team with that space to deal with the issue. So I don't think it is unreasonable for us to proceed, and I agree that we should proceed, Chairperson. Now, I just want to raise, before I come to the application, 3 preliminary issues, Chairperson. Firstly, Chair, is that we must reassert the fact that the Section 194 process is an oversight committee of Parliament, determined in terms of the rules of Parliament and what the Constitution invites us to do. So to think of it otherwise will take it out of the remit of this being an oversight process. So in essence, what the committee is doing is to ensure that there is accountability on the side of the PPSA, in particular its incumbent. It is nothing other than that, and understood as such. Therefore, the rules of Parliament are applicable to this process, including the unique rules that apply to it per se. The second point that I want to raise preliminary is that throughout this process, we have adhered to due process and ensured procedural fairness, in particular towards the PP, because we recognize that appearing here, she is appearing before an institution that is well-resourced, an institution that has got the means to conduct a process such as this. But we have bent over backwards. At times, I consider to be unreasonable, but I think that in the interest of ensuring that there is fairness and justice done, this committee can demonstrate that it has provided procedural fairness to the PP. The third issue is that I want, Chairperson, and through you, to reassert that this is not a Mazzoni motion. Frequently, we are being referred to this as a Mazzoni motion, and now it's even reduced to writing. This is not a Mazzoni motion. I wouldn't have participated in a Mazzoni motion if it was that. The nature of this process is a parliamentary process that has come through a motion tabled in the National Assembly and agreed to by the National Assembly and therefore sanctioned by the entire National Assembly. So it loses the name of its originator. It assumes the name of a decision of the National Assembly and nothing else. On the application itself, Chair, I think, yeah, let me start by saying that my observation is that the application is brought in this process prematurely. This is an application that the PP in any way can bring to review the decisions of the committee. And that it is not appropriate to have brought it currently. But in line with all the other applications, it's clear that it is meant to add cumulatively to us delaying the entire process of coming to a decision. My other observation, Chair, is that listening carefully to what was presented at the time it was by the evidence leaders, there was no intention to defame anybody or to label anybody as being racist. If there was that intention or interpretation that there was such an intention, it was not clear to me at the time this was made. And if it was, the chairperson would have immediately attentioned us to the fact that this is now going beyond what is reasonable and therefore that it is irrelevant. I did not hear you, Chair, at the time rule on the irrelevance of what was presented on the fees or whatever on the expenditure of the public protector on legal fees, because that is the focus of what we wanted to check. And I do say, Chair, that I think that I respect the evidence leaders. I think they've got impeccable credentials, particularly as Black female advocates in the profession. I don't think that they would have done this. They would have attacked their peers and fellow professional people deliberately. And I think it is the duty of this committee to protect them. First, in their legal profession as outstanding advocates, but secondly, for the fact that they themselves come from the ranks of the disadvantaged. Chair, I think that it is in the public interest to ensure accountability and that the process should be completed within reasonable time with due regard to procedural fairness. And therefore, Chair, that I think that this request or motion from the public protector should not be acceded to. And as I usually say, Chairperson, and I think I will accuse you of bias in not listening to me on this one. I say to you, we are not without legal recourse ourselves as a committee. We can go to court to compel the public protector to participate directly in this process and have it finished. If we go to the Concord directly and raise this as a matter of public interest, the Concord will give us at least the space to raise the issue that we are sitting in a process which is being handled unnecessarily by the public protector. So, Chair, my view is that we should proceed and reject the motion.
Thank you, Honorable Nkosi, for your contribution. Points noted. I now recognize Honorable Nodada.
Thank you so much, Chair. Good morning, Chair. I hope I am audible, Chair.
Yes,
Chair,
we can hear you.
Yeah, I just want to raise three things, Chair. The first one is that we must never assume that procedural fairness is one-sided. Procedural fairness applies to all the stakeholders involved in this particular process of the inquiry. And therefore, when we are subjected to motions of this nature, which have an element of toxic masculinity written all over them, by people that are doing a service for the state in the interest of the public, which, by the way, will interrogate anybody who takes money from taxpayers from the state if we need to do so, for the purposes of ascertaining on whether or not this will be helpful in the process of our inquiry in determining the allegations or the alleged charges that are posed to the PP. And it becomes abusive, Chair, when we constantly as legislators responsible for public interest and ensuring that fairness is not just only to the PP, but to the people of South Africa in which we represent, that we get applications of this nature, which seek to delay this particular process for whatever agenda without us even making any form of determination on what has been presented to us. So I think we must condemn completely this toxic masculinity that has been posed in this committee in the past couple of days, with people making frivolous and ridiculous allegations. We now have become a committee of, discussing racism or purported racism from whatever of you people have seen it from, which seemingly they live in their own bubble. This is a public process. We are a people's parliament. We are legislators representing the public, including any entities and stakeholders that participate in our process. We must ensure that we are being fair. So for us to be dealing with things like this, that as if we're incompetent to determine whether the evidence leaders or the assistance that we get as a committee is either assistive to us or is prejudicial to the stakeholders that are involved here, is actually undermining, ridiculous and abusive. Whatever response that the PP's team is going to send to us in writing, we'll simply just note that, Chair, and we must reject this application as is, continue with the inquiry as intended, and making sure that we are being procedurally fair to all those that participate in this process, including the public that we represent that are interested in being publicly protected at this particular process. I agree with Honorable Herem that there's a lot of sensationalism, and we've had to deal with a lot of sensationalism, including this particular application, which must be condemned. And I hope that we can all agree that we condemn any form of sensationalism and not just nitpick as to what those sensationalists are. Now, Chair, we've got a particular reasonable time frame that we need to participate and be involved in this process. And that reasonable time frame cannot be continuously derailed by things, honestly and genuinely speaking, that are irrelevant to this committee, more so than anything that find no reasonable facts. And we are now subjected to things that we've read, to listen here for hours on something that we could have read in an email and make a determination, like we always do when it comes to the long reports that we get in Parliament in any case. And then we come here in this committee and we make a determination and we move on. If we decide that we are considering those things that are being presented to us, we'll then do so. But I think being subjected to long hours of oral presentation on things that some of them would have read sometimes is really ridiculous. But Chair, I want us to be able to reject this particular application and continue as a committee and make sure that the PP accounts to the public of South Africa through this procedural fairness, not just only to her, but to the people that have elected all of us to be here as legislators. Thank you so much, Chair.
Thank you, Honorable Nodada, for your contributions. The last hand will be that of Honorable Siwela.
Thank you, Chairperson.
Sorry, Chair, my hand is also up, so.
You will be noted. Thank you, Honorable
Okay. Thank you, Chair.
Mautwe.
Thank you.
Oh, hands are now coming up. Okay, it will be Honorable Mautwe. Just hold Honorable Suela. Honorable Mautwe, Honorable Bolomisa.
Thank you.
Honorable Mulder. In that order. Proceed, Honorable Siwela.
Thank you, Chairperson. Thanks for the opportunity. Chair, I just want to align myself with my colleague that this committee or the motion is not Mazondo's motion. I think we need to emphasize this, Chair,
I didn't
because
get that. You spoke about Mazondo. Who's Mazondo?
I'm referring to the motion that it is not Honorable
Mazzoni.
Mazoni's
Oh,
motion.
okay.
Yes.
All right.
Not
Thank you.
Mazondo, Mazoni. Because Chair, if we leave it like that, it is really misleading. And I feel we are being undermined. We have been deployed or mandated by the speaker according to the rules of the House to come and participate here. And the motion has been adopted by the House. So I believe we need to emphasize this point because it is continuing and we're not happy about that. We feel being undermined. We are here as a responsible representative to represent our constituents. So we need to be given space to execute our duty without any fear or favor. Chair, I want to agree with the speakers who indicated that we haven't observed any misbehavior from our evidence leaders. So hence we are really seriously rejecting that application. The application on its own, according to other speakers, it is maybe I can say that it is disturbing our way moving forward. So with due respect, can we be business-like, stick to our business? This is not a court. I think I have indicated this several times that we're not judging anyone, but let us allow this process to proceed and allow the PP to come and account because she's accountable to Parliament. So those other issues, Chair, is just a way of derailing this process. So hence, I support those who are saying we need to continue without any fear or favor, and I'm rejecting that particular application, joining other honorable members. Let us be focused. Let us proceed. We've got a program. We need to stick to the time frame because this is waste of state money and time. Thank you, Chair.
Thank you, Honorable Suela, for your contributions. And now recognize Honorable Mautwe.
Thank you very much, Chair. Chair, from the onset, I want us to be clear that we support the removal of the evidence leader. And I'll elaborate more. I'll deal with it more on my input. And secondly, Chair, this motion is the motion sponsored by Mazoni of the Democratic Alliance. It is there in Parliament. It didn't fall from the air. We didn't have a group called Members of Parliament sponsoring a motion. The motion is the motion sponsored by Mazoni, and people must come to that realization that it is the truth. It is there in Parliament for the public to know and to see. And this motion went to Parliament. It was voted for by the DA and the ANC. The EFF rejected this motion. So we can't come here and sugarcoat things and say it's not a Mazoni motion. It is. It remains a Mazonian motion. It recorded in the books of Parliament of this country. Now, Chair, I must say that despite consistent warnings, you have successfully turned this process into some palace politics. From where I'm sitting, Chair, I doubt the public is aware of who between us is politicians and who is administrative staff and who is evidence leader. What is the role of each of us? Because it just looks like all of us were elected politicians from the way we are running this meeting. whether Advocate Bauer or Fatima or my colleagues, because it seems people came here with preconceived conclusions, and this was meant to be some rubber stamping process as long as the ANC and the DA are in agreement to crucify a black woman. Well, the less said about Fatima's conduct and remarks, the better. We have come to accept that the administration of parliament at times struggle to separate its role between being members of structures of the ANC and the legislative mandate to serve parliament made up of members of National Assembly and NCOP. Chair, we have warned against this and we are doing it once again. And it is the Parliamentary Legal Office that appear to struggle the most. And we saw this even with the Adult Committee to amend Section 25 to allow for land expropriation without compensation. If it's not incompetent legal advice, it is entering the political arena through the back door. If they want to be elected as politicians, they must say so. They must not come here masquerading as Parliament Legal Office when they are actually politicians. It appears, Chair, that Ms. Fatima, her only concern is that we finish this inquiry before the PP's term of office ends. And if we don't, we will not be able to get her after that. This is what she sticks with every time she opens her mouth. She's thinking about the date of October. No, we must push towards it. It doesn't matter whether this process to her is fair or not. This seems to her to be her only priority, regardless of whether this process is unfair, prejudicial, or discriminatory. It is wrong, Chairperson, for her to do that. From where I'm sitting, Chair, it doesn't even look like there's a concern over the credibility of the outcome of this inquiry. So to want to ask her questions, I'll be just wasting my time and wasting the time that you've given me to engage on this. Now, let me turn to you, Chair. Or before I deal with you, let me turn to deal with the matter of evidence leader. If you remember, Chair, earlier on at the beginning of the process, you kept reminding us that the evidence leader is here to help the committee to hear all sides and hear all evidence. But thus far, she has done the complete opposite, not only in a shocking way, but with a lot of racist insinuations and display of disregard of the dignity of her own colleagues. We don't know how much Parliament has paid Advocate Bauer to date, despite endless commitments by yourself, Chair, that you will display that information. Now, it looks like it's a dirty secret of how much she's been paid. We're asking again, Chair, how much is Advocate Bauer being paid per day by Parliament? And how much has she earned so far since the beginning of this process? I'm asking this possibly for the fourth time. We've also written a letter that has not been responded to. Can the public be taken into confidence on how much is Advocate Bauer getting so that we're all clear what we're dealing with? Chair, let's deal with the merits of the submission of by the PP. It started with you, Chairperson. Your conduct from day one has been biased and at times bordering on being unparliamentary because you think as long as the DA agrees with you, you have the majority and you are correct. And in the process, you undermine basic tenets of fairness. Doesn't matter whether I'm alone, Chair, but the truth remains the truth and you must listen to it and rule on the truth, not on the numbers. We've been saying that every time we take this platform. Even what you're doing now is plainly wrong, Chairperson. You want to paint a picture that the PP lawyers are failing to submit documents in time, but you don't tell the public that the evidence leader herself was late to submit the document. And that's the consequences of her lateness of submission. The evidence leader is trying to spin a despicable conduct here. The application for her removal is on the display of legal fees, and we will deal with that in a moment. But the reality is that her conduct has always been problematic, Chair. You can hide it, you can sugarcoat it, you can try to run away from it, but it is the truth. We wrote twice to the Speaker of Parliament to demand the removal of Advocate Bauer. She started with colluding with Ms. Fatima, and together they were busy writing affidavits that witnesses themselves, they came here and told us that they did not understand. We complained about this and submitted ample evidence to this effect. But the argument that the figures were displayed to deal with the subject of irregular expenditure were all conveniently forgetting that this is the very PP who got clean audit. She didn't do her own audit. It was the Auditor General that did her audit. Why did we call Mr. van der Merwe, who didn't hesitate to further the stereotype of corrupt black lawyers instead of the Auditor General? The idea that we simply put names of people with amounts next to them because this is indigenous. We submit questions all the time to Parliament, Chair. You know that yourself. We submit written questions for written reply, and when it comes to names, because of this sensitivity, the question appear with wording like name submitted, meaning the name was submitted directly to the minister. We don't easily put names of people with figures because we know what this can do to the public. There was no reason, and we are convinced that Advocate Bauer played a racist stereotype, and we don't believe she was naive to that reality. You can all collude to keep her here as evidence leader, but you will have to deal with the outcome of a discredited process. This is not the first time we're warning you, Chair. We have dealt with this even with Nkandla. It's shocking, actually, that Advocate Bauer, she's not voluntarily stepping down, but we should remove her and proceed with our work. She has entangled herself in a mess. There is no need for us to keep her here. Let's remove her and continue with this process. We therefore submit, Chair, as the EFF, that Advocate Bauer must be removed as the evidence leader from this process. I thank you.
Thank you. Thank you, Honorable Maute, for your contribution. Just to assure you that you are not alone. You are with 23 other members, both in the M46 and on the platform. So you're not alone in the meeting. Thank you. I now proceed to Honorable Olomisa.
Sihlalo nekomiti ebekekileyo. Ndizawube ndiyibeke ngelwimi lam le nto kuba le nto ithethwa ngabanye bethu apha sebeyibekile ngesilungu kuba ndibacacisela abahlali. Kuncedisana nale ngxelo ifikayo. Ikhona ingxaki esinayo nge-evidence leaders. Phaya ngaphambili amangqina ebebeze nawo bewancedisile ukubhala i-evidence yabo. Sithe xa sibabuzayo kwezinye areas, but hayi kange ndiyifake ngokwamkele nina bifakwe ezi-evidence leaders. That on its own serves to tell you uba abathembekelanga aba kuthiwa zii-evidence leaders. Secondly, umnumzana uHeron lo imember yeParlamente apho utshilo okokuba thina as members of parliament nakubeni i-rules and regulations zifuna kange ke side sibe sihlala phansi sichaze okanye sivane ngee-witnesses ezizawuza apha. Sizibona nje zichweciswa emva ngobusuku and nezo witnesses ubunintsi bazo bunengxaki.
Point of order. Chairperson.
Honorable Ngola, you are disturbing. Please mute. Honorable Olomisa is on the platform.
I'm raising a point of order.
Continue, Honorable Olomisa.
On a point of order.
The point of order. Just pause, Honorable Olomisa. Is it a point of order?
Yes, Chair, it's a point of order.
Okay. Go
Chair,
ahead.
Respectfully, Umkhulu convicts that witnesses apha zicwecwiswa ngobusuku. And at no stage that we have brought witnesses during midnight here. So that point is misleading. So it's out of order. Thank you very much.
We out to roll out by
just before you come
But
in.
Ngola is out of order, Chairperson. Why is Ngola doing this to us?
Just before you come in, Honorable Olomisa.
Chair.
Thank you, Honorable Ngola. I have noted.
He's out of order. Rule him out of order, please, Chairperson.
I have not recognized you, Honorable Maute. I'm on the platform.
Yeah, but
Honorable Ngola, I've listened to the points you're raising. I will attend to those issues as the chairperson. I would want Honorable Olomisa to proceed. Honorable Olomisa, please continue.
He wants to be chair. He wants to overrule you, chair. You see, Ngola, he must be dealt with.
Honorable Olomisa, you are the one on the platform. Nobody else has been recognized.
Masimncede lo uphakamisa point of order. Noba zingene ebusuku okanye zingene kusasa emini. Into endizama uyicacisa uba ezi witnesses ezinye zazo zithe ezinye zee-paragraphs ezikwi-evidence zazo bezingafakwanga ngabo zii-evidence leaders ezenze loo nto. Bear in mind, but aba bantu babhalala lento as witnesses. Phansi zonke bezi-subject of disciplinary hearings or action phaa kwa-public protector. Ngoku sizokwenza into sort of an appeals court apha sizi-members of parliament. Izolo sivile uba i-witnesses okanye i-witness ebifamba izile apha kuba ingakangikhonjwe zezi-evidence leaders. Bezikhomba ke phofu on our behalf because asizazi thina. Lena ifikileyo kwathiwa hayi ayikho ayizubhukishelwa ayizuthwani. I wish these evidence leaders zinovumela zonke ezi witnesses zifuna uzotestifya and bazincedise nazo uba ngaba zifuna uncediswa kwenziwe i-evidence eyiyo. So lilonke ke i-UDM ithi Mr. Advocate Mpofu nomama uMkhwebane besi-appointwe iParlamente apha i-office kaSpeaker. Uba aba bakhonjiwe mabasikhokhele lezo evidence leaders ke kuyabonakala uba zinento ezinayo i-agenda. Sicela into kokuba ubhalele uSpeaker umxelele uba kukho i-treatment engekho right nengekho procedural. Failing which ufune i-remedial action as court niye kube nisingxole lapha. Xesha sinalo. Nkosi.
Thank you, Honorable Lamisa. I hope as we chair here and do this, as a Ngoleni, senze umsebenzi weParliament. Like a civil. I now want to recognize.
Apikwangu Advocate Mpofu andibhekisa ngakuwe ne-colleagues. Uba akakho sethi makahamba ye ku-Speaker phuma kwakapho bakaphendulwa kakuhle Jones Court asizube singapheliyo apha.
So diwana lapho e-court.
Thank you, Honorable Lamisa. Honorable Melder.
Court awudibana.
Thank you, Honorable Chairperson. I hope that I'm audible. I'm not sure about the load shedding and that the signal is clear or not, but I'll try to be brief.
You are audible. Please proceed.
Thank you. Thank you, Chairperson. No, Chairperson, colleagues will recall that on the first day of the first of these hearings, I said I hope that the intent is not to delay this process and to keep us busy for whatever time may be until the year. And we gave him the benefit of the doubt to proceed with the proceedings, and we all went along that process. Now, this application is basically the 6th attempt to sidetrack, as far as I'm concerned, the proceedings that we are dealing with. If I can come to the specific application, it was a written application by Mr. Mpofu on behalf of the Public Protector. It was 33 pages. I worked through that. The evidence leaders responded to that in a comprehensive reply of more than 60 pages. I also worked through that. And in the reply of the evidence leaders, they dealt with the allegations in the application. My concern is that the structure or the attempt to have an outrage or an outcry of the public, to a very large extent, was based on the whole racial issue. And my concern is, Chairperson, that that is based on not the actual facts that was put in front of this committee. It's based on a half-truth. The evidence leaders made it very clear that they put the full facts on the table, that there was no racial intent or racial bias. As a matter of fact, all the facts were put in front of this committee, dealing with not only people from one specific group in South Africa, but all the advocates that were involved. Even the letter from the Johannesburg bar that was presented to us yesterday is based on not them. That's why look carefully in their letter or in their statement, they say seemingly malicious. Yes, seemingly, because if they've got the full facts, they would know that there was no malice in that whole process. So there's an artificially created outcry, which is not there. If you check in terms of the happenings out there, there's an artificial bias, and the whole process we saw playing out yesterday. Yesterday, we gave Mr. Mpofu more than an hour to talk to his nothing in those oral evidence or that presentation of yesterday was said that was not already in the written application that we had to deal with. Chairperson, I've been involved in many processes in Parliament. I've served in all the Nkandla investigations and in numerous others. Section 25, you can go through the process. I can assure you that this is the most fair process that has been in Parliament since 1994, and rightly so. Why do I say that? Process like this, in dealing with an issue like this, to create a very fair, absolutely balanced process. It is the most fair that I've seen. That doesn't mean that the Public Protector's Office can't go through what they see as unfair and that they suspect it. That the Public Protector can't wait to get into the evidence chair and to convince the committee of the other side of the story. This is now their opportunity. We've been waiting for this for quite some time, and I find it rather strange that they are not grasping that opportunity immediately. For example, the witness that we are trying to get in front of the committee on her behalf, the first witness. I was astounded yesterday. It was amazing to hear that that witness has not been prepared. Surely that's number one witness they've had enough ample time, months, to identify this committee. And I hope that that can still be done today. Surely they have now prepared that witness. Chairperson, in conclusion, I think the next application for a removal will be against either the caterers or the sound division, because we've seen this playing out one after the other. I guess the caterers will be next in line. I really want us to move on. I think the Public Protector's team, Mr. Mpofu and friends, have had sufficient time to bring what they want to do. They did not supply us this morning with a response. I don't think we've received it yet. I also support the dismissal of this application, that we proceed immediately and continue with the work. And when the next application against the caterers come, we will deal with that as well. Thank you, Chairperson.
Thank you, Honorable Mulder. You have just raised caterers, and then I think it takes me to tea once you raise that issue. Just want to indicate, colleagues, we have received the application as I'm getting it from the committee secretary, and I indicated it be sent to you immediately. And I want to read this from the committee secretary, that dear Chairperson, find attached PP's reply to the evidence leaders. Please indicate if I can share it with the rest of the committee, which I did. Quite clearly, the submission was received 11:08, 38 minutes later than what was committed in the WhatsApp this morning, meaning 10:30. Let alone the fact that we would have expected that last night or first thing this morning. And so it's been sent to you. I am now going to ask that we take a 20-minute break. We'll come back and then I will summarize our decisions and the ruling. If in the 20 minutes you've picked up anything in the 13 pages of the supplementary, because this is supplementary, the main application was made yesterday. This is supplementary. If there's anything you would have picked up before I summarize, you will be able to do so. It is now on record. And now it's being 11:20. We adjourn for tea for 20 minutes. Back at 11:30 or 11:40. Thank you. We adjourn for tea.
Recording stopped.
from the tea break. Just perhaps before I ask Ms. Ibrahim if there's any quick responses she wants to make, I will, as I indicated, if members have picked up anything that they want to put on record from the supplementary response that arrived at 11:08, can quickly do that. If none, I'm going to ask Ms. Ibrahim to make a few responses. None. Thank you. Thank you, honorable members. Ms. Ibrahim.
Thank you, Chair. Chair, just one or two things on the comments made by Honorable Helen. Don't know if members will recall because it seems a lifetime ago, but when we started this process, our initial advice was steering towards not having evidence leaders, precisely because we felt it's important that members do the work and are seen to do the work themselves. But of course, following the Constitutional Court judgment, which provided that the PP or any Chapter 9 head, that the legal representative could actively participate in the committee, a decision was then taken that we would use evidence leaders. But indeed, the committee is at liberty at any stage to direct those evidence leaders. As far as I recall, the witness list was provided quite early on to all members. And unlike a criminal trial, there is no case, as I said, that the evidence leaders put forward or that they've closed. So at any time, if members feel that they wish to hear from a particular witness, that can certainly be raised and we can go back and look at that. Then, Chair, there was a question as to whether we could take steps through the courts to ensure that the process continues. I'm not entirely sure on what it would be that we would be asking the courts to compel the PP or her team to do. But nonetheless, Chair, the courts have been clear and the Constitution is clear that the committee can control its own internal proceedings and that Parliament can do that. So I think the committee must be firm and needs to do what it needs to do. There are ways and means and other legal avenues available to the committee already in terms of powers and privileges and in terms of the Constitution if the committee wishes to exercise certain of its rights. So we would not want to approach courts unnecessarily and get the courts involved in what should be a parliamentary process. But of course, if there is a specific issue that needs to be raised, we can always look at that at the appropriate stage. Thank you, Chair.
Thank you, Ms. Ibrahim. Honorable members, just from my side as a chair, hopefully I would have listened to you all very carefully in the way of making the summary, which is the decision of this committee. I think you have all expressed yourselves and on the application itself, but you have also raised quite a number of issues that we need to take into account process-wise, starting with Honorable Heron on the issue of the witnesses and the specific name being mentioned. And I think that on the issue of Mr. Cilliers, there is nothing wrong if myself and the team would look into that matter, because that's a witness that has been mentioned and would have been central on a particular issue of whether to do this or not to do that. So I am comfortable that we can take up that issue. But it's always been my understanding that when we issue a witness list, we would expect members to indicate either way. So your comments are well received, Honorable Heron, in that regard. Even as we continue with the rest of the witnesses, I think, because at least up to this point, there's never been a stage where we would have refused calling of a witness. I still remember there were also a name of Nemasitsi that was mentioned, especially by members. So I don't think that would be a problem, but we take that as a homework. So that maybe before we conclude, we are able to, because we'll check the relevance of that. But I think from where I'm sitting, I'm in your own space as well, that I do find relevance in Mr. Cilliers on the free and the dairy matter. Two, I think colleagues, I have properly recorded strong views of the economic freedom fighters through Honorable Member Mautwe in recording their support for the removal of the evidence leaders. That is clearly noted. On the next issue that you would have raised, I just want to, I've said this before, and I'm going to ask that members refrain. I've asked members to refrain from this. And Honorable Maut continues to repeat this. I find it very unfair and unwarranted, the continued attack on the professional team, the staff members, on the work they do under the direction of this committee, on the insistence of this committee. I've made this point before, that when you don't like what they present, you shouldn't be attacking the messenger. Let's deal with the message. If it is the advice being given to us and you don't like that advice, let's respond to that advice appropriately without attacking a person and even going further and reduce his professional team that works with us and label them as politicians. I find that very unwarranted. I've said it before, and I think I want to firmly make this point, not only to Honorable Mautwe and any other member, that we might need to take different steps in this regard, because it is not helpful to continue doing that. We engage robustly amongst ourselves as members. I'm not going to ask you to pull your punches on me, Honorable Mautwe. Give those punches. I will absorb them. It is part of our terrain as members of parliament in the way that we engage. And at the end, I'm not going to take it personally, but I would want to protect members of staff or professional team, including, as Honorable Nkosi indicated, the evidence leaders who in their responses have coined it appropriately that they are the arm of the committee. That's part of our designation, that they are part of this. We'll protect them. Honorable Nkosi makes a very important point. We were very conscious in appointing these two Black women. And it gets to be so unfair and unacceptable, the kind of attacks that get to be leveled against them purely for doing their work. That's the point. The next point, I think I've heard you, Honorable Holomisa, giving an advice and a guidance to the public protector legal team. You within your own rights, we can't take an issue with that, advising them that they need to take this matter further in different platforms and forums, including the office of the speaker. I think you've made that point very firmly. I have not heard you saying you support the remover, but I've heard you giving that advice, and I'm noting that advice as a chair. But besides Honorable Mautwe and advice given by Honorable Holomisa, all the members that would have spoken, basically 10 of them out of that 12, there was unanimity on the issue of this application of the public protector not meeting any threshold bears no relevance to the work that we're doing, and that there's no way that we can accede to it, and therefore that this application must be dismissed and rejected. Well, members would have motivated a lot around how they feel, what the purpose of these applications are. I've noted that whether members feel that this is more of a stalling process, delaying tactics, and that is taking us away from our mandate. And I would refer to that as these being distracted by these incidentals. So we've got to come back and focus on the work that we need to do. As I introduced yesterday morning, this last phase we're getting into is a set of last witnesses, and key amongst those witnesses, central, that Honorable Suka says the public, it has a public interest and the public wants to hear from the public protector. We're looking forward to hear from the public protector to give us reasons why she must be exonerated. And we can't delay that any longer. And I think, honorable members, on that point, I want to indicate that we have set a timeline in concluding in December, concluding on Monday, the set of witnesses that we have lined up to agree. I don't want to disturb that, but I do want to place this on the table in response to that perhaps as a committee, let's, and I will lead that as a chair together with the team in terms of the January program, that let's have dated sessions and have the public protector to lead and be the first witness in January in terms of how we work the program, because it can't be that when you are into a DC process, the person must go to a DC, must tell you when he will come or she will come. And then if anybody else amongst members who has got a grief with that kind of homework, we say so, because we would want to ensure that we don't delay any longer hearing from the public protector. There might be witnesses even after she would have come forward that we can listen to, but we do need to get to that point. And so I want to make that. And so effectively, there's no case for evidence of the evidence leaders to be removed. I think on matters of misconduct, perhaps that's an advice that we can give. If there's a misconduct alleged on the part of the evidence leaders, the Legal Practice Council is an address that we can give them. You go to the Legal Practice Council and complain about misconduct, not in the inquiry. We can share that address for the Legal Practice Council on issues of misconduct. It doesn't belong to us. We are not that professional body to attend to those matters. And I think it's going to be important that we do that. Otherwise, honorable members, we have also then asked that the evidence leaders and the team of the public protector joined us around 12, because we'll take a few minutes break as we're waiting for them, and then relay the decision immediately, but also allow Advocate Mbofu to start leading arguments as would have planned. And so that in the afternoon, as we indicated yesterday, we are able to swear in the witness. Thank you very much. Anybody with having a grief on that summary? You speak now. None. Thank you, colleagues.
No, Chair, I have a grief.
Yes.
Yeah, so it doesn't matter what you say. It really doesn't move us an inch. If the parliamentary legal office comes here and behave like politicians, we're going to say that. We're not going to sit here and be told on what direction we must take as politicians when it's blatantly clear that these people have got an agenda. So we're not moved by anything that you say, or anyone for that matter. We will state here in this committee what we feel about the parliamentary legal office. And we've demonstrated to you that even in the Nkandla case, it was the same thing. Even during the expropriation of land without compensation motion, it was the same thing. They are continuously repeating the same thing that they've been doing. So we're going to call it out. We're not scared of anything or anyone for that matter.
Honorable Maute, your grief is noted. Thank you. We'll take a few minutes break. Colleagues, thank you.
Recording stopped.
has been with us this morning. Let us welcome back the public protector and the legal team, as well as the evidence leaders. We would have pushed further than what we anticipated as the time when we're going to call you in. So for whatever inconvenience would have caused there, our apologies. But we had to attend our business in the manner that we did. I want to quickly, therefore, take this opportunity with the committee having concluded its deliberations on the removal application to briefly summarize that on record with everybody's presence as to the kind of decision we have taken, that after some deliberations by members, we took our time, we listened to the application, read it as it was submitted on time, we read it, we listened to the oral presentation, we interacted with the submissions of the evidence leaders in writing. We waited without success to receive the supplementary, therefore, from the PP team, either last night or first thing this morning. And would have given some 20 minutes thereafter, once we had received it, for members to peruse and reflect on it, which we're able to do. Just to indicate that we therefore came to the following conclusions as the committee. That firstly, there would have been one clearly articulated and a strong view, which would have been in a minority that supported the removal of the evidence leaders, firmly put on the agenda by Honorable Maute of the Economic Freedom Fighters. There would have been a further advice call it free advice, preferred by the leader of the United Democratic Movement for the PP to take some of these issues further in different platforms, including that of the speaker. The committee had noted that, but beyond the first two that I would have mentioned, that the committee was unanimous in its consideration of the application, and was unanimous that the application has not made any case for the removal of the evidence leaders, and that we are not in a position to accede to that application, that we decline and reject it as the committee. And therefore, this is what I would want to put forward to you. There would have been other matters for committee work that we summarize, but this is the main point and the gist. We would forward a formal and a written response about our decision to the public protector in due course. But as things stand, that's a decision of the committee. The committee has not acceded to the application for removal by the public protector. And we therefore, having placed that decision, we want to proceed with our work. And for that, we are going to allow Advocate Mpofu to make his leading arguments and thereafter go to the witness that is joining us today. I thank you. Advocate Mpofu.
Yes, thank you very much, Chairperson. Good morning, afternoon, everyone. Chair, yes, before I go to the lead, I don't know what the leading argument is. The opening address. I will just indicate firstly, you've just made a remark about the lateness of the document that we were supposed to send you this morning. I hope you received our apologies. Excuse me. And it was, yeah, as we indicated in the message that we sent you, it was really matters beyond our control. We tried everything, including probably sleeping for 2 hours just to get it done. But as we indicated in the message, and as you may know, we don't have secretarial services here. That's why we do our documents in Gauteng. And we also had to eventually Mr. Nyathela, we were only able to make contact with him after 9 p.m. because of the delays. The time that we had indicated to you about his travel turned out to be a false start. And eventually he traveled, I think at 5 or something like that, and only arrived in Cape Town at 7:30 or just after 7. So that just compounded the issues which anyway we had raised with you, that the time was insufficient and inadequate, and blatantly unfair, because the whole thing was really precipitated by the failure of someone, I don't know who, to send us the document on Sunday, actually on Saturday, as we were promised by you, Chair. But we noted that that document was firstly a day late in its production and a day later in being finished to us. And all that is fine. We heard that our document was 38 minutes late, but a document that was a day or 2 days late, there's no problem with that. And also the difficult position that we were placed in through no fault of our own, without anybody apologizing. Chair, it's really sad how the public protector is abused in this process. But as we've said from day one, we soldier on, and we will continue to participate even in the face of all that. The other thing, Chair, that I just want quickly to point out is that we therefore find it very objectionable, to say the least, that the alleged deliberations could take place without us having been given that proper opportunity to respond to the 66-page document that was presented. And without this time, as we said now, it's quite clear that everyone is just, intent on rushing to the stage of the chopping of the head. Because now it looks like the rules have even changed. No longer the opportunity of members to seek clarity from us, which you also extended yesterday, was also miraculously withdrawn or forgotten or whatever happened. So it's the first time that there's an application where we have not had an opportunity to clarify certain things to members who, most of whom are not legally trained and may have wanted to understand the issues raised by both the evidence leaders and ourselves. And some of the issues, for example, that were raised by you, Chair, about the Legal Practice Council and all that, which we had made clear that this was not a forum to lay a complaint. I mean, you should understand that we know that both ourselves and our client know that, being lawyers ourselves, but it looks like we're just talking to deaf ears on all those issues. But Chair, I just want to make a specific objection about the submissions made by the Parliamentary Legal Office, which basically was just a repetition of the submissions made by the evidence leaders. And it's blatantly unfair to allow a situation where somebody is going to be giving opposing arguments regarding our submissions in our absence, misrepresenting those submissions, and even questioning our integrity and intentions, and accusing us of being involved in delaying tactics and all sorts of things like that. And you, Chair, have had the temerity to say that members should not attack the members of the legal staff because they must not attack the messenger if they don't like the message. But we get attacked here left, right, and center in your presence, and we complain to you. We've been insulted on Twitter, on all sorts of places in this room, everywhere. And we've appealed to you to protect us. But you've just told us now this morning that your duty is to protect the parliamentary staff and the evidence leaders. Who will protect us and who will protect the public protector in your committee if your duty only goes to that extent? Must we be insulted, or are you the chair only for the evidence leaders and the parliamentary staff? But so, Chair, that's another issue. If we can be given an opportunity to respond to the submissions made by Ms. Abraham, which are completely out of line, and as I say, just mimicking the evidence leaders' 66-page document, almost identically. And I think that issue was also raised with you, and you did not pay any heed to it. The last point I want to make, Chair, is that also something you said that, sorry. Yeah, well, you called our application incidental. No, we must deal with the incidentals and put it away. And you say that you must focus on the work which you need to do. So we had pains to explain to you yesterday that the work that you have to do includes all the obligations that are placed upon you by the Constitution and by the directives and the terms of reference. One of them is that you must ensure that this process runs fairly. It's not a favor that we're asking from you. It's a must. You must ensure as a committee that the process is run fairly and reasonably. And if anything that has happened in the last 2 days is anything to go by, then fairness and reasonableness is the last thing in your mind. It looks like you agree with Ms. Ibrahim that all that needs to be focused on is the date of the end of the term of the public protector. In other words, whether the process is fair or not fair, or reasonable or not reasonable, or in line with Section 34 of the Constitution or not, that is, you don't see that as part of your business. Because Chair, we made it clear again, contrary to what Ms. Ibrahim has said to this committee, Section 34 of the Constitution, which binds you, makes no distinction between a court of law or this committee. Section 34 says you are equally entitled to fairness in a court of law and in any other forum such as this one. So to keep on telling us that this is not a court of law is the same as saying that, well, this place is now exempt from the Constitution, which is an absurdity. Nobody, least of those of us who practice in courts of law, can ever mistake this for a court of law. But we're saying that the Constitution applies equally, and somebody in the position of Ms. Ibrahim should know that instinctively, instead of regurgitating that senseless suggestion that simply because this is not a court of law, then the rules of fairness must be suspended and not applied. Yes, so that's the issue, Chair. And also, she's also wrong that public participation does not involve taking heed of the voices of organs of civil society and members of the public. We did not make the accusations that we are accused of making against the evidence leaders. All we did was to bring to your attention what is out there, what is has been said, what has been sparked by their conduct, and what is in the perception of the public protector as a result of that. So again, people are going on off a tangent here as if we are the ones who have made the statements that were made by the Johannesburg Society of Advocates, for example, which represents more than 1,000 advocates. When it says conduct is seemingly malicious, that's something that must be taken into account by this parliament. You know, it can be poo-pooed as, I can't remember the term they used, external forces or something like that. There are no external forces. Those are people who are part of your constituency, who voted you into power to be sitting into this in this committee. And they have a right to participate in whatever way they want in this parliament, because it's their parliament, not yours. So that's those are just some of the issues, Chair, that should be disturbing to any right-thinking South African. If this parliament can degenerate to levels even below those of a kangaroo court, of actually not giving us a chance, firstly, to finish our submissions. We asked you for 10, 20 minutes yesterday just to finish our submissions. You denied it unreasonably, without any reason, because there was no reason for us to have to adjourn at 12:05 as opposed to 12:20. You've practically denied us an opportunity to, or rather made us to work overnight, the whole night and the morning, compiling documents, which you were just going to ignore so easily and not wait for, even when we pleaded with you. You know, that's the worst form of abuse, Chairperson. Abuse of power, abuse of position, and an assault on our dignity. But as we have said before, you have the power now, but it should not be abused in this fashion, Chair. As I say, even an apology for not giving us a document that we deserved to be given on a Saturday. It was late, it was not given on the Sunday. It was late, it was not given until we raised it here this morning. And when we are reacting to that affront that has been done to us, we're treated like, as you said yesterday, as if we're in a kindergarten. If anything is going to be learned from your process, it must be what not to do and how not to behave, how not to treat people. And even if that will be the small contribution that we make to the development of our constitution, it will be quite something. But anybody involved in this farce and facade should be ashamed of themselves, of any part that they play in degrading and insulting our constitution. Thank you, Chairperson. All right, we now want to refer you, Chairperson, to clause 4 of the directive, which gives us the right to make a second opening address. As I'll try, Chairperson, you remember I made a promise. I'll try to keep the promise I made to you on the first day, namely that we won't retraverse the other opening address because this one is supposed to serve a different purpose. Where there's some overlap, I will indicate, Chair, that there's one or two areas where there's an inevitable overlap with the issues that were raised earlier. But as I say, I won't belabor them, I promise, just so that we make progress rather than, there's no point in repeating what's already on the record from the previous address. Chair, the purpose, maybe I should start right there to distinguish the two. The reason that we, at that stage in our engagements with the evidence leaders in fashioning the directive, that we made this proposal and were grateful that it was adopted for having a second opening address, really talks to what you and I have said and other people have said here repeatedly, namely that this is a novel process, you know, and uncharted waters, virgin territory, all sorts of metaphors have been used. And therefore, we then took the opportunity in the first opening address really to try and situate this whole process in the larger scheme of things. So it was a more broad-based kind of opening address. And we had sought, without wasting the time of the committee at that stage, that when the time comes for us to call witnesses, we would then have this opening address, which zooms more into the nuts and bolts, as it were, of the evidence itself, the witnesses that we're about to call, what issues might still be remaining. And the purpose, Chair, is really to assist. It's not to waste your time. On the contrary, it's probably to save your time, because once we have mapped where we're going with the evidence, then everyone will then know this witness slots here, this one talks to that, this one talks to that. Without us, every time there's a witness, we have to kind of situate that particular witness. So we hope that it will be seen in that positive spirit that it was intended for, which was to assist the committee to navigate this, what you've called this phase of the process. Chair, we focused in the first address. You'll remember we started by, and I'm going to be long on this because I'm not going to be long on this, so that I don't repeat, I don't have to re-argue it, but I'm just reminding us. So
maybe that's what's going to happen.
Yeah. Yes.
Long.
Thanks, Chair. So our opening salvo the last time was that we were here under protest because of the countless constitutional violations that we identified at that stage. And again, I won't go through them. We also pointed out, on that I must say that, I mean, given the experience of what has happened in the past 4 months, if there was such a thing as a double or treble or quadruple or quintuple protest, then we're now under that protest, because really it has been quite an ordeal, to say the least. But be that as it may, we're still here. We will be here, and we're going to see this through. And contrary to the gratuitous insults of the likes of Mr. Mulder and the others, we are more than ready and keen to see the finality of this, and also to see the public protector, as we indicated on the first day, giving her side of the story. There's nothing that we'd like more than that. But that must never be mistaken to saying that we are so keen to do that we're just going to subject ourselves to a kangaroo court and not raise objections as we're entitled to constitutionally whenever there's no legal process that I've ever heard of where people are not allowed to raise objections at any point about anything that they perceive to be unfair. I'm sure when you've watched movies, you've heard people objecting to about this, that, and the other. All that is in the aid of achieving fairness. It's not just a game that we play of objecting. It's what we are here for. It's what we are trained to do. It's what we are hired to do. Is to protect justice and fairness. Otherwise, we shouldn't even be here. That's why the Constitutional Court ruled that we must be here. It was not just to fill up these chairs. It was to ensure that there's justice and fairness in this process. Anyway, so that's the issue that we did raise. Then the other issue that we raised, Chair, was, and I'm raising this for a specific purpose. Even then I raised it and I said to you, Chair, I know this one issue doesn't belong to you, but I'm raising it for broader context. And it was that when this process goes to the National Assembly, we will ask at that stage for a secret ballot to be the method by which the matter is going to be determined. And as I say, Chair, and it's not, I don't need you to make any decision on that. I know that's not in your province for now, but I'm raising it in the context of this particular committee, the experience we've now had. When I said that on the 11th of July, little did I know that 4 months later, we will be in a situation where it is clear that we will need that protection from the voting kettle syndrome of just instinctive or don't even know what to call it, crowd behavior. So it's going to be a very crucial aspect of making sure that people indeed vote with their consciences and not necessarily, well, if I don't have to motivate that, you can just read the case of the UDM versus the speaker, where we won the right for a secret ballot vote in respect of, I think it was a motion of no confidence as opposed to an impeachment in that particular case. We won that right in the Constitutional Court to avoid exactly this idea of people just, you know, as I said to you, if we say today is Sunday, we can all vote that it is Sunday, but that doesn't mean it's really Sunday. Then the third issue that we did raise, Chair, was that, well, I've already touched on it. the value of the legal representation that was afforded to the public protector by the Constitutional Court must be looked at in its true perspective. And I won't repeat what I just said earlier, but one of the perspectives from which it must be looked is the fact that this parliament literally, and it has now been demonstrated why, fought tooth and nail, to put it mildly, until the highest court in the land to ensure that the public protector should come here without legal representation, or without legal representation of anybody who's really participating in the process, tooth and nail. Now we can see why. By now, I think she would have been bent at stake in the first 5 minutes had she not had the protection afforded to her by our Constitutional Court, and we must really appreciate that. Because even with legal representation, you know, the guards of the guillotine are boiling already. But I can assure you, Chairperson, that we'll do everything, but everything in our power to protect the rights of the public protector and to protect our Constitution, if nothing else. Doesn't matter who says what, it doesn't matter what insults are held at us on a daily basis in this place. We are equal to the task. And if we have to bring an application now in the next 5 minutes, we will bring it. If we feel that there is an injustice that is meted out against the public protector, we will voice it. If we have to go to court, we will go to court. Make no mistake about that. We will not check from those responsibilities. So nobody must think that we can be easily intimidated, you know, by repetitive statements about this is the 4th or the 5th or the 6th or the 100th application. Yeah, and lectures, you know, about how we should prepare witnesses from people who've never prepared witnesses in their entire life. They wouldn't see no witness preparation from their elbow. But so we must make it very clear that I just wanted to underline that. Otherwise, we shouldn't even be here. Then we will really be wasting your money. So those were some of the issues, Chair, that we raised before. In today's address, we will focus on, one of the issues that I must touch on just because it's topical now, which we did discuss, both sides, by the way, was the role of the evidence leaders. We raised that at the beginning. They raised it themselves, I'm surprised now today they tell us that we're saying that they are prosecutors, but they themselves in their opening address said that they are not prosecutors. And we said the same thing. They are not prosecutors. They're not supposed to be prosecutors. The reference to prosecutors is exactly a contrasting one. It is a standard that is set by you in your terms of reference, not by us. At paragraph 4 of the terms of reference, or 5, which says that the inquiry is inquisitorial in nature, is 5 in nature, and the evidence leader does not act as a prosecutor. And whoever drafted your terms of reference was not by doing that, saying that they are prosecutors. They were saying the exact opposite, that they should not guard against behaving as prosecutors. And what we said yesterday is that if their conduct does not even meet the standard of the prosecutor, then clearly it cannot meet the standard of the evidence leader. And that point seems to be lost in translation. And that's the issue, Chair. So we can't be told here that unless if we were dreaming, everybody was here, Chairperson, when Mr. Samuel said that these judgments that are put in my statement, I've never read them. You were all here. Everyone was here when Mr. Jana said, I'm referring in her affidavit, I'm referring to paragraph 117 of Mrs. Mokhaladi's affidavit. And when I asked her, have you ever read that affidavit? She says, no. I've never seen it in my entire life. So how did she know what is in paragraph 117 or 118 or 119? But now everyone has amnesia, and we're told that it has never happened that the evidence leaders made up or spoon-fed evidence for witnesses. But that's fine, the record will speak for itself. That's as far as looking back is concerned. Well, Chairperson, let me just say one thing. Sorry, I apologize. I should have said it in my earlier remarks before I started with this address. You said something which I don't know whether well, if it was serious or whether it's actually going to happen or not, but I'm sure we'll get some communication. But you said something about that when we come back in January, the first witness we must call is the public protector. Well, Chairperson, I have news for you. We are going to, unless otherwise ordered by somebody else, we're going to call the witnesses in the sequence that we choose to call them, as we're entitled to. Not even in a kangaroo court. By the way, I was once part of a kangaroo court. It's just that we used to call them the people's courts in the 80s. But not even there can you I used to represent people, by the way, so they used to slash them before I come so that I don't represent them. But not even there, Chairperson, do they ever do what you are now purporting to do, which is to prescribe to a party or to a person who is facing the jeopardy of such a serious matter as an impeachment. What's next? Are you going to tell us what questions to ask or what we must wear when we come here? No, that's, I hope that idea will end where it started, Chairperson. Otherwise, you must just prepare yourself for quite a serious resistance on that front, because as I say, I don't know where it will end. Right. Now, Chair, for the record, we want to say, just to situate the next discussion, the evidence leaders, as you might know, Chair, by now, have called 18 witnesses up to where we are now. The inquiry has now set, I think this is probably day 40. And it has been spread over, the evidence led by the evidence leaders was spread over a period of exactly 4 months, having started on the 11th of July until the 11th of November 2022. And of the 18 witnesses called by the evidence leaders, 15 were current or past employees in the Office of the Public Protector. One was a so-called expert who said he was not an expert. And one was an alleged member of the rogue unit. And the other one was Mr. Pillay, the one who allegedly retired at midnight and was rehired 1 minute later. Those two witnesses related to the so-called Godan cases. So those were the 3 exceptions. But for the rest, the 15 of the 18 witnesses were employees or past employees of the Office of the Public Protector. And that is in that context that we made the remark that we had made that this inquiry, well, firstly, some of those employees, in fairness, dealt with specific reports that feature in the charges, for example, the Fred CX and so on. I think about 1 or 2 each. But for the rest, this was like an HR or CCMA process of an array of disgruntled employees or those who have a particular view about chasing deadlines and ensuring clean audits and serving the public. As we sit here now, Chair, the witnesses, we have given you a list of witnesses, and some of them will, and I'll come to that, will then talk to some of that evidence almost directly. But others will cover a new terrain that was not covered. And of course, the public protector, whenever we call her, whether it's as the first witness when we come back in January, or the second one, or the 6th one, or whatever, will then deal with the relevant evidence that was directed at her. And Chair, this is where I was apologizing to you about covering when I said there would be some overlapping issues. One of those, and it's an issue which I want to raise sharply, Chair, but without elaborating, because we have exhausted that issue here. It is the issue of the scope of the inquiry. Very important, Chair, fundamental, key issue. And I'm not raising it as you, in case you might fear that I am, for you to make any decision or anything. The committee has made this decision about it. And we've said our piece about it. But I'm raising it purely in the context of navigating the way forward. so that we will, and at times we will tell you when that issue raises its ugly head, which will probably in respect of every witness. The reason why that issue is crucial, Chair, is because, you know, contrary to this hype about delaying tactics and we don't want to get to the end of this and all that, there is no single issue that delays this committee unnecessarily than the fact that we have to cover ground which is completely irrelevant to this process. We have to cover this, even this hullabaloo about legal fees or legal costs or whatever you call it, and people's names being bandied about, is actually much ado about nothing in relation to the motion at all. Firstly, we have explained to you that even if you take the Mazone motion as at face value, let me put it that way, it refers to legal fees, which any first-year student will tell you is a completely different things. It refers to legal costs, which will tell you that it's different from legal fees. That's the first thing. Let's assume for the purpose of that the motion is looked at face value. But what is worse, Chair, is that if you look at the report of the independent panel, that issue, whether it's legal fees or legal costs or legal whatever, that is not one of the charges that the independent panel said there is prima facie evidence about. So completely, I mean, it's just a waste of breath to have to deal with that. So even if so that's the one thing. That's on the what we call the narrow approach. On your wide approach, then the issue of the interpretation of what was meant by Ms. Mazone when she raised this issue, or including what was meant by Mr. Mileham when he raised it, as well as in the context of benefiting lawyers. That now has to be clarified on the so-called wide approach, but I'm saying that clarity would actually be unnecessary because the issue is not an issue which has passed the threshold of prima facie evidence. And the committee cannot be examining issues where there's not even prima facie evidence about. And by the way, Chair, while we're at it, we have received a message that the only person who can assist us in that respect, that's Ms. Natasha Mazone, who is the author of that, and she will know whether she meant legal fees or legal costs or whatever, has now sent a letter given to the letter that I sent to you yesterday, or rather I referred to yesterday, has sent a letter that she's not willing to come and assist the committee. The committee that was set up as a result of her misguided endeavors and the charges that might need to be interpreted or explained. She's not willing to do that. So that's another issue, Chair, that you will unfortunately have to deal with. And if history is anything to go by, then we may never know whether it was legal costs or legal fees, because that's how we roll here. the more relevant evidence is, the less likely that the witness will be subpoenaed. And the less relevant, then we'll have an array of 15 people saying, things or coming to give us evidence about documents they've never seen in their lives. But that's where we are. So I'm saying, Chair, that that issue of whether is the narrow or the wider approach, it will be resolved whenever it gets resolved. But my prediction is that it will turn out to have been the biggest cause of any delay, particularly if it is proven, which should be common sense, that the independent panel was not just a waste of time. It was a filtering mechanism to ensure that only evidence that passes a particular threshold should see the light of day here. Just as the process of the speaker as well, when the motion is initiated, one of her jobs is to ensure that the motion is in order, quote unquote, which means that it complies, it has prima facie evidence. But as I said, Chair, that will be the burden of the committee. It decided that it will not I'm sorry, Chair, just 1 second. Yes, sorry, Chairperson. I wanted just to round off that point by referring you to the minutes of the proceedings of the National Assembly on the 16th of March 2021, where the motion, as you know, was when the motion was adopted by predominantly, well, the ANC and the DA and others. And it said, consideration of recommendations of the independent panel established in terms of Rule 129U to conduct a preliminary assessment. And then it said that the question put was that the report of the independent panel, which recommends that the Assembly proceeds to conduct an inquiry into the public protector on the specified grounds, be agreed to. In other words, on the grounds that, if you read the independent panel report, it's called Annexure A. They tried to make it easy for the National Assembly by putting an Annexure A where they summarize which grounds have passed the test. And that's what happened. That motion was then agreed to, and the report accordingly adopted. In other words, the report with all its qualifications adopted. But I suppose that will be a debate for another day and another place. All I'm saying is that we might be at least wasting half of everybody's time by calling witnesses on issues that did not pass the test. Then, Chairperson, I want to, if you allow me, okay, I've spoken about the witnesses already called. I'm going to now speak about our witness list. And I'm going to say, Chair, I've indicated, I think, I'm not sure if it was formally here or it was in writing. We've indicated that we might have 1 or 2 witnesses who are not on the witness list. But we undertake, Chair, that whenever there are those amendments, whether it's taking someone out or putting someone in, we will make sure that there's proper communication and timeous communication and submission of statements on time. No, we, as I said, contrary to popular belief, nobody wants this thing to move as quickly as possible than the public protector. So you'll get our full cooperation in that regard, Chair. Then the next topic that I'm going to talk to I'm just going to round off something. It will then be to zoom onto the real purpose of this address, which is to talk about the specific charges and how we're going to approach them. The issue that I said I want to nip in the bud quickly is the fact that some of the witnesses that were called by the evidence leader, some of those 18 witnesses were not, or rather did not finish their testimonies. And for example, somebody like Mr. Pillay, who was somewhere in Holland or whatever, had indicated at that stage that he was available only for that particular day. But now it looks like the interpretation of that is that he was available for that day for the rest of his life. And, you know, irrespective of whenever it is, we must just live with the fact that he cannot be asked to come and finish his evidence. This is somebody who had volunteered to assist the committee, presumably in response to your advertisement on the public participation. But now when we're saying he must just simply finish his evidence, and we're given all sorts of stories and obstacles. Because if he's here to assist the committee, then it must be that he's going to assist everyone in the committee, including ourselves, who might need his assistance. It can be that he gets blocked at the point at which we want his assistance in the form of cross-examination. But again, that's where we are. Ms. Baloyi, the same thing. She came, so the record speaks for itself. She was not even answering questions, going off some unnecessary tangents, and making up stories about people calling other people madam and all that, which was quickly proven to be false. And when we went to finish the hair cross-examination, again, nowhere to be found, and no assistance from the chair or anyone to ensure that she just does the honorable thing of finishing her evidence. So the former employees were Mr. Mahlangu and Ms. Baloyi, or Mr. Mahlangu, who finished his evidence, and half of Ms. Baloyi, I should say. For the sake of completion, if anybody is interested, the witnesses that were called were Mr. Hassan Abraham, Johan van Lochenberg, Tebucho Kekana, Spelo Samuel, Vusi Mahlangu, Futana Tibele, Baldwin Neshunji, Ivan Pillay, Divuani Chaulule, Dicheni Retani, Kumbi Chalela, Reginald Ndo, Basani Baloyi, Ponasakho Mokhaladi, Temgosi Stole, Ntoriseng Mutsisi, Nelisiwe Techane, Niels van der Merwe. And they fall into the categories that I've already explained. And they gave what I call a mixed bag of evidence on various topics, including management of deadlines and backlogs and related meetings, which we will deal with in our evidence as well. System of issuing so-called Audi letters and other human resource issues, which we will deal with in our evidence. Allegations of harassment, victimization, and intimidation, which nobody really sustained, but which we will deal with. There are impressions of the evidence of the public protector as a leader, which we will deal with. the underlying and endemic issues bedeviling the institution, including budgetary issues. And then they dealt with this issue of so-called legal fees, which, as we've indicated, is not even covered in the terms of reference, rather in the charges. And we say, in our view, broadly speaking, the following issues need to be addressed or kept at the back of the mind as we move forward. The role of the evidence leaders, I won't say much more about that. A lot has been said yesterday and today. The role of the public protectors, legal representatives, I've also said enough about that this morning. The role of the chairperson, we've traversed that, it's in front of the courts now. The composition of the committee and its alleged bias, that's also in front of the court. And then the confusion, which I hope will be cleared, and I'll say something about this, over some of the legal concepts, such as cross-examination, relevance, attorney and client privilege, full legal representation, and the like, which, as I've pointed out before, some of these terms don't mean what they mean in normal English. It's important to unpack them. Maybe I should interpose, Chair, by saying that one of the witnesses that we will be advising you about, maybe when we get back, will deal with some of those aspects as an expert, just to explain some of the things that seems to be dodging the attention of the committee, even this morning, as I say, as to what the duty to fairness, what does it really mean? And particularly your role, Chair, to ensure that there's fairness in the process. Is it one that should be skewed for one set of people, or should it encompass all of us? And what does it really mean? And then there's the bedeviling issue of the status of the court judgments, Chairperson. That also falls under that category. Hopefully, whoever has to deal with that will also unpack it. Whether they are binding, as Mr. Mulder seems to believe, or whether the public protector is entitled to bring evidence to refute whatever prima facie evidence might be contained in them. Issues of generally just the law of evidence and maybe some separation of powers. So we will lead evidence on that because it seems that it's quite necessary.
Thank you, Edward Mpofu. At that point, we're going to take a lunch break.
Thank you,
and we'll be back at 2.
Yes, thank you, Chairperson.
Thank you.
Recording stopped.
everything is okay with the connections. Mrs. Kanyaza Twala, are you there?
Good afternoon, Chairperson. Yes, I'm in the meeting.
Thank you.
Thank you.
You now know that nothing is predictable here.
Exactly, Chair.
It's not just the members that are being checked. Thank
Yes,
you.
no,
With
I'm
that,
here,
colleagues, thank you. We resume and I hand back over to Advocate Mpofu. Continue his opening remarks.
Thank you, Chair. Yes, thank you, Chairperson. I just wondered if you allow me, Chair, just to go back to the issue that I had raised about the necessity of the evidence of one of the witnesses that we intend to call Ms. Mazoni. When I reported to you about the letter we received from her, it was from indirect accounts from behind me here. I've now had an opportunity to look at the letter itself, thanks to the lunch break. And I just want to say, Chair, that basically the letter, I mean, I won't read this in full, but it basically says that she notes that we ask her to testify and for two reasons. Firstly, to explain the intention of certain aspects of the motion. And secondly, to deal with the motivation behind the motion and whether it was improper and so on. And then she says her evidence is irrelevant and therefore she declines to give evidence voluntarily. So I just wanted to confirm that it's the voluntarily that I wanted to emphasize, which means now we're in the land of subpoena. It's in now, as Nelson Mandela once said, it's now in your hands. So that's where we stand with that matter. And as I say, it's obviously a strange one. It's the first time in my life I hear a complainant who says somebody stole my car. And then they say, come give evidence in court. They say, no, I'm not coming there. But I suppose there are complainants and there are complainants. Now, where we were, Chair, is I was, oh, by the way, yes, I was getting to the matter which I preempted earlier. My heading here says the sequencing of witnesses. I jumped the gun because I was worried about your remarks this morning. But here what we said, Chair, under the sequencing of witnesses was that the way we had structured the sequencing is firstly in broad categories, but already it's not working like that. As we've always been saying, witness handling is one of the most difficult things of our job because they have lives of their own. We prefer those cases where you just go and argue your papers and not have to deal with the witnesses. So ideally, Chair, we would have wanted to structure it like this. Let's call it blocks. The first block would have been the expert witnesses, one or two, one to do broadly with the role of the public protector and that kind of thing. And then maybe the expert that I was talking about on evidential issues. We also have a slight possible problem, Chair, which I will raise with you maybe tomorrow morning. One of our witnesses who was based in another country may no longer be able, I think is the word that is correct, to testify because she may have been appointed to some office, high office that might make it difficult, but we were still talking. In fact, what we asked her was whether she would not, in any event, even if she can't testify, hand in a statement, in which case we will then hand it at that time. But I'm just giving an early warning about that, Chair. So it will be then those types of witnesses, the general expert witnesses. Then we will deal with the issue of incompetence, the allegation of incompetence broadly and narrowly. And by that I mean, there'll be people who will be talking about their own perception, but there'll also be, those who speak specifically to specific charges of incompetence. Then we'll do the same thing about misconduct. The misconduct charges, as you know, Chair, particularly the Freddie and the CX matter kind of straddles both topics here. So we'll deal with those. And then the HR issues. And again, I'm just a tag that I'm giving. You know what I mean? It's the internal public protector employee issues. And so on. Yeah. So that's how we had grouped the witnesses. So you'd have a witness like Mr. Godan, just to take randomly, would be dealing with the misconduct aspects that deal with his reports. And again, I'm using the words loosely. When I say the Godan reports, we know what we're talking about, so-called rogue unit and Pillay retirement, and so on. And then there's the catch-all group that will deal with specific issues. Ms. Mazzoni, when we eventually get to her, will then assist us on a broad perspective of what, because she's the cause, she's the reason we're here. What drove her to get us to be here, and we've heard that this process in total is probably now run into almost 100 million rand in its different guises. Yeah. So it would be important to situate it here. But as I said, Chair, for each witness, I undertake to you that it will be clear as we start with the witness which of those subcategories we want to address. And if there are overlaps, we'll point them out. Now, Sorry, Chair, I just want to make sure I'm not leaving anything else before I deal with the last topic. Oh, yes. In terms of the broad approach, Chair, we understand, as we should, that the process is inquisitorial, but ultimately the committee is still expected to make findings of fact. And this can only be done in our respectful submission on a balance of probabilities after weighing up the evidence in relation to each charge. But I don't need to dwell on that, because when we do the closing address, obviously we will define what we think is the test and so on. And I think there's an idea that just came to my head now. We might even be able to, between ourselves and the evidence leaders at that stage, to agree on some of the basics of how the evidence should be approached. Now, So we will take a two-pronged approach. Obviously, some of the issues, and Chair, I don't want to commit you or the committee to anything at this stage because it's too early. Excuse me, but we will take the position that if no evidence was led on any issue, it's either well, if we deal with it, we'll deal with it just for the sake of completion, but we're not going to waste your time on those kinds of issues. But again, we'll be in touch with the evidence leaders so that we're not leaving out something because we think it is not being pursued. Meanwhile, it turns out that it is being pursued. Right. Now, if you allow me, let me then just zoom into some of the specific issues that deal particularly with specific reports. We have the evidence that we're going to call first, as we have indicated, is that of Mr. Nyathela, who was going to be followed by the other witness I was talking about. But we think that we will be able to call Mr. Lamula as our second witness because of these developments. So we're trying to make sure that he's basically not on standby. Fortunately, he doesn't work far from here. When we come back, Chair, we will kind of finalize those types of general or expert witnesses by calling one outstanding witness in that category, and then we'll go according to the blocks that I defined. Now, if I may, then I'll pick out some of the important aspects of the charges or of the motion. Sorry, Chair. I just wanted to round off. Sorry, Chair, I'm jumping back to some thought that just came to my head, which I'll lose if I continue. So I'm tying this up to the point I was making earlier about Ms. Mazzoni. And I would refer you, Chair, to 1.5 of the directive, which is the motion. It defines what we mean by motion, and we did this deliberately, I think, because there was already contention between us and the evidence leaders around this issue of the so-called broad or narrow approach. And what your directive then defines, it says the motion means the motion of Mrs. N.W.A. Mazzoni, MP, dated 21 February 2020, to initiate an inquiry in terms of Section 194 of the Constitution for the removal of Advocate Busisiwe Mkhwebane of the office of the from the Office of the Public Protector, South Africa, on grounds of misconduct and/or incompetence. So that's the official legal definition of the word motion. It means, and that's why when we call it the Mazzoni motion, we're using the reliance on this. We're placing reliance on this clause. But this will be, I'm sure this was going to be debated if and when she continues with the attitude of not wanting to assist the committee. All right, back to where I was saying, I'm just going to talk about CX, and again, I'm not going to dwell on it. but just to give you a kind of guidance of where we will go when we deal with that particular report, which straddles both the misconduct and incompetence charges. Our position will be, which we will argue at the end, and hopefully the witnesses will assist us in sustaining that argument, will be that it should be clear by now, after the witnesses that have been called, that the CX related charges have been totally misconstrued, both in their formulation and how they've been presented, and maybe even how they have been characterized by some of the court judgments. Because the gist of those charges were that the public protector came up with some outlandish idea about the Reserve Bank and its place in the South African economy and so on. And kind of, just woke up one day and put those in a report, and in some effort to put the markets in a tailspin or whatever. So, but we now know that, oh yes, and then this other, the SSA bogey, yeah, because the originators of this motion are of the idea that she's a spy, quote unquote. So everything that has to do with SSA then must be viewed with suspicion. So we have in this category the fact that she had asked Mr. Moodley, who used to work at the Reserve Bank, to when she was formulating the wording of what turns out to have been clearly her own idea for a long time, and one discussed with economists and all sorts of people, and researched by Mr. van der Merwe. But we'll need that all up from the point of view of the public protector to show that there's no substance in the charges, and that she was acting totally within her remit, which allows her to, quite frankly, make proposals and suggestions and to any organ of state, including Parliament or anybody. But so we'll deal with that in that way, and we'll rely heavily on Mr. van der Merwe's evidence, who really has given the committee the genesis and evolution of that idea. Then we will also deal with whether the recommendations for a constitutional amendment, which forms part of the remedial action, falls outside the mandate of the PP. Sorry, I've already said that. And bottom line, as with all the other charges, that whatever conduct the public protector was involved in was not an impeachable offense by any stretch of the imagination, and that actually that suggestion.
No. Okay, thank you. Proceed to get them both.
Thank you, Chair. No, but PE efficiency is important. But so I was saying the bottom line, Chair, will be that there's not even a semblance of anything approximating an impeachable offense, at least not as defined in the rules of this committee. And here I can indicate the evidence of the public protector herself will be key in dealing with all these aspects. For obvious reasons, she was the one who was interacting with all these people, whether it was the Mr. van der Merwe or the SSA people or the presidency. In the charge, there's even a suggestion that the amendment was done on the advice of the presidency, which is quite something. Then if we go to Freddie, Chair, in a similar vein, and I'm doing a broad brush. I mean, there's going to be a lot of detailed evidence on these things. Here, one of the things she's accused of is that she narrowed the scope of the evidence. I think that's already been shown to be false. That she excluded certain politicians, including the then premier of the Free State, which has also already been shown to be groundless, I think, by the witnesses called by the evidence leaders. That she avoided dealing with the so-called Gupta leaks. That's also been shown to be false. In fact, the opposite was shown, that she was insisting on using the Gupta leaks. That takes us, Chair, if I can digress a little bit, to the question raised by Honorable Heron this morning about the evidence of Advocate Celias, which I agree with him and you, Chair, that it's something that would have that would at least ostensibly be relevant to the proceedings of this committee. I just want, maybe in support of Mr. Heron's proposal in general, that this whole idea of witnesses that the committee might want to call needs, and I obviously don't need to prescribe to you, Chair, needs to be dealt with as soon as possible so that we know where and how it fits within this. But specifically to do with Advocate Celias, I can warn you that you're going to need a lot of persuasion, or she's definitely, we've tried to get her to come here, and I know that the evidence leaders have also tried.
Maybe if you're on the subject, Advocate Mpofu,
yes,
it wasn't just a question of trying. It was a question, and maybe in context, Advocate Celias is retired from the Office of the Public Protector. She's living in a rural area on the outskirts of Free State. I've forgotten the name of the place. And she's busy with carrier pigeons or racing pigeons. But the fundamental difficulty with the evidence is that after a long period of time, she has no memory recollection of events, in a way that after several attempts to talk to her have not. We've sent batches of documents down. We've tried numerous ways to ascertain, and we hit the brick wall. And so we couldn't actually work out whether, actually we came to the conclusion that we didn't think that we were going to get anything meaningful for the committee. And in conversation with Advocate Mpofu, he, in having those difficulties, reached the same conclusion.
Thank you, Chair. No, that's true, and it's, yeah. I mean, she made it very clear. She's a farmer now. She's not interested and all that. But I think the point I was making is that the general idea of identifying those kinds of witnesses is something that we support. It might be that with this particular one, we might.
Sorry, Advocate Mpofu. Sorry. If they are witnesses,
I did not recognize you. Please switch off your mic. Thank you. You are baiting this point of digression. And where the matter has been put here, we hear what you're saying. It won't stop us pursuing. So I want you not to go any further.
Fair enough, Chair.
On the matter. Thank you.
No, you're quite right. In any event, it was a digression. But for me, the big point is that the committee should respectfully apply its mind to what witnesses it might want to call, particularly once it has had, obviously you know which witnesses were called by the evidence leaders. Once you have had sight of our witness list, that's when you might be able to do that exercise. Right. So I was still talking about Freddie. Then I say that it's also alleged that she failed to investigate certain aspects for ulterior or improper reasons. In other words, for example, where if she says something was not done because of financial constraints, that is found to be false, and so she'll again, Chair, the main witness around the Freddie issues will be the public protector and one or two of the other employees who might have been involved in it. And maybe I should say this, Chair. Our approach again is going to be, but also plus probably for legal argument at the end, is going to be that we rely obviously on what our witnesses have to say, but obviously we'll also rely on what concessions were made by the witnesses called by the evidence leaders on the key issues. Not, I don't mean all the concessions that might have been made when we were testing credibility and so on, but on the concrete issues that form part of the charge. Right. Then there's the FSB case. There's not much really that turns around that case. I think it was only mentioned in passing by Ms. Mokhaladi. So we're assuming that it will just be an issue of analyzing the report itself and looking at the objective facts and determining whether or not they match the what you call the charge. So an example is there's something in that charge about the Rule 53 compilation. I think all the witnesses made it clear the public protector has got nothing to do with compiling Rule 53 rules notices. So we won't spend half a day on that. We will deal with it just for the sake of completion. But we're not going to waste your time on issues like that. Just 1 second, please, Chair. Thank you, Chair. Yes, the public protector just reminded me that that FSP thing, subject to what I've already said, it also has relevance to the issues such as the disciplinary action taken against Ms. Mokhaladi, Mr. Madiba, those people who were in her unit. That's correct. So again, we'll deal with it in that context. You'll remember that's the one where we were, when I was cross-examining her about the so-called self-imposed deadlines and so on. Yeah, so we'll deal with it in that context as well. Right. Then the next one is the CR17 report. Now, on the CR17 report, which is mentioned in the chart sheet, you'll remember this is the then hotly contested issue of whether the public protector was acted beyond her jurisdiction in investigating what she felt under the Executive Ethics Code, being the, let's call it fundraising activities of the then Deputy President of the country in order to achieve political office, which was done. The court, we know, they found that this was what do you call it? A private activity. Yeah, and unlike the current one of Pala, which is supposed to be a public activity, but is a private activity. But that's just, I digress again. Yeah. We will also deal with that issue, test that conclusion on jurisdiction, whether the public protector, and again, Chair, let me say, when we do that, this must be clear, because it goes back to this thing about the binding nature of legal judgments. We don't want to address the thing at that level. What we will be convincing you, Chair, and your committee is that the public protector at least did not act in the manner specified in the rules of intentionally or grossly negligently or recklessly or whatever, making these decisions. So even if let's assume it's true that the CR17 fundraising is a private matter. I mean, I don't believe it myself, but I'm not the one who's being impeached. So the point is not whether I believe it or you believe it, Chair. The point is whether the public protector subjectively at the time that she acted believed it genuinely or not, and so on and so on. So as I say, I don't want to dwell on that. When we do the legal argument at the end, we'll go to town about what the test really requires. Yeah. So I don't want to traverse that. So the issue will be whether the finding that the president benefited personally and also in a public sense of the word, whether the committee and the public will believe that after hearing the public protector that she was doing that out of some personal vendetta, or she was just doing her job. And whether she was, which is even worse, what Mr. Ramaphosa actually has said is that she was driven by political motives, which would be a serious charge if it was true, but it's false. So we'll also demonstrate the falsity of that charge. And I use the word charge in a more general sense. And whether in doubting the bona fides of the president in respect to his version that this money was raised without his knowledge or at arm's length, and without his involvement, holds any water, that anybody can have R1 billion or whatever the true amount is raised on their behalf, and when they go around addressing those fundraising dinners, but not knowing that the money is going to benefit them. We'll deal with that in the backdrop of whatever the outcome is of the effort to get Mr. Ramaphosa to testify, to justify his utterances which have led to these charges. So if we succeed in getting him here, he'll say it himself. If not, then the public protector will give her version, which will probably be uncontested as to what the issues around the CR17 stroke Busasa issues. And that will involve the public protector having to share with the committee and the public what it is that made it to come to those conclusions. And as I say, I'm hoping Mr. Ramaphosa, if he knows what's good for him, will then contest those if he wants to. We'll try to give him the opportunity. But if he doesn't, then the evidence of the public protector must then be accepted as uncontested. Then there are what I call the Godan cases, Chair. I've already touched on this. It's the so-called rogue unit and the Pillay retirement case. An issue that is central to that, of course, Chair, is an issue that you might remember at the early stages we grappled with, and that's the issue of the IGI report and its place in this whole saga. Again, is the so-called SSA bogeyman. The minute anything to do with intelligence, then, oh, there we go. We told you she's a spy. So we'll deal with that. And this is one of the areas, if I may say so, that is one of our key grievances about our recent application that the public protector has mounted against the evidence leaders. in that we will demonstrate that the aspects of that particular judgment, relevant judgment, that make it clear that the charges around the IGI report are completely unfounded, which we would have expected evidence leaders to highlight, even or at least to concede once they were pointed out. And so just so that we save the time and not have to lead evidence around that. But that's a debate for another day. Then there's an issue, Chair, where this issue rings through almost all the reports. And let me just articulate it like this, because it's also going to be an issue of argument. There's almost in every court report where the public protector has been criticized, ironically, it has been around the issues of procedural fairness, which we think this committee has no respect for. But that issue almost invariably manifests itself like this, Chair. They'll say Mr. X or Miss X was implicated in the particular report, and Miss X or Mr. X was not given their right to Audi, which in the sense that they did get a Section 779 notice, and Miss X, in terms of the law, deserved to get a Section 79 notice, and therefore the public protector acted unlawfully in breach of the procedural fairness standard, which is all fine up to that point. It's the next step that we're going to contest. And we're not going to say if Miss or Mr. X was not given a Section 79, we're not going to say they were given, because they were not given. But what we will contest before you, Chair, which might be a different thing to what was done in court, will be whether you take the next step, which says so-and-so didn't get Audi, and therefore the public protector was biased, was motivated by bias or bad faith or political motives or whatever is ascribed to that particular failure. Yeah. So we will be very careful to explain again with the even through the witnesses what it is that we are disputing. So an example is Mr. van Lochrenberg. We dealt with this in relation to him. If he didn't get the Section 79, he didn't get it. We're not going to say he got it. But we have said that A, the public protector took all reasonable steps to reach him, sent people, they went to the wrong address if they went to the wrong address, but that was not driven by bias or malice or political motives or whatever. And that's why he didn't get his notice. And so we'll try and simplify that issue. Again, this Mr. Godin is quite central in the Godin cases. That's why they're called the Godin cases. And Chair, just for your information, if I allow me to digress again, we got a letter yesterday from Mr. Godin's legal team, who have informed us that they will give us the total response on the 5th. I think that's next Monday, on the 5th, as to whether he's coming voluntarily or not. That's just an update here. So he may or may not be in the Ms. Mazzoni League. Then, Chair, there's what I call the other issues. And there it's issues like the issues raised by Mr. Samuel, for example, about allegations of sweeping an investigation under the carpet. Those things will be explained, sufficiently, hopefully. The things about Mr. Zwane attending a birthday party and that kind of thing. So those things will be dealt with. There were alleged attacks on Judge Potterl, I think, a matter that was at some stage referred to the LPC that will be dealt with. So it's those kinds of charges that you find in between the main charges. Then the last category, Chair, or basket of charges that we will lead evidence on, which will be mainly through the public protector and the employee witnesses, will deal with the so-called harassment, victimization, and intimidation. These lead directly to the discussion on incompetence and or misconduct. And our version, which is that actually, far from being incompetent or misconducting herself, the public protector is the shining example of what a leader in the public sector should be, which is to care for the people, which is to be hardworking, as even her worst enemies have described her as that, and which is to make sure that when you leave the office, if you leave it in a much better state than how you found it, in relation to all these things, to work at the work ethic, the backlogs, and so on, and governance issues, the clean audits, and the like. So yeah, those are the key categories. So there's just one quick thing, Chair. It's this thing about, we debated with the witness Tajane about whether the accusation of so-called victimization, as you remember, is broken into two. There's the main charge and the alternative. The alternative is the one that has the list of names. And the alternative, one of the important things about the alternative is that it's the real allegation there is not so much that the public protector victimized those people, but it is that she effectively sent the CEO to victimize them on her behalf or at her behest. I can't remember the exact wording, but something like that. And those people have been listed, and some of them, again, will check this with the public protector, with the evidence leaders. Just to give you an example, there's been no suggestion whatsoever that Mr. Matlawe, who's one of those 7 people, I don't even think anyone has mentioned him. I think Mr. Kekana mentioned him in a different context because he was part of the quality assurance or whatever. But there's been no suggestion that he was victimized either by the public protector or the CEO. So we can't now then go and call evidence about that unless, again, if our discussions with the evidence leaders, if they say, well, you must still call Mr. Matlawe or whatever. Yeah. So, and I can go through the list. Mr. Samuel, obviously, we won't call because he was here. He's one of the 7. Mr. Madiba, the late Mr. Madiba, we can't call. Again, Mr. Lamula will say something about him. Mr. Matlawe, I've just mentioned. Ms. Mukhaladi spoke for herself. Kekana spoke for himself. Baloi spoke for herself. But we'll be able to refute that charge in both its incarnations, both in the main charge and the so-called alternative charge. Sorry. Yes. Okay, I'll just make a note. Thank you, Chair. Let me just, okay, so I'm done with the issue of the alternative charges. I think I've already addressed the thing about cost versus fees when I was talking about something else. I've also discussed the issue about the SSA. Yeah. The one issue that we just wanted to round off is that in terms of the main cases, one, one of the common themes as well is the issue of personal costs, and we will address this both for evidence as well as which in our view is maybe what Ms. Mazzoni had in mind, but we might be wrong, but we'll address it anyway because it's also relevant insofar as some of the allegations of or rather, let me put it the other way around. Insofar as some of those costs would have been awarded because of the allegations of bias, political motives, whatever. Yeah, and so the personal costs and the punitive costs would have been tied to those aspects. So let me put it simplistically, Chair. If we succeed to convince the committee that in a particular case, the non-furnishment of Audi was not improper in the sense, then logically, then it would mean that for that reason, if the public protector convinces the committee that she had genuine reasons or valid reasons not to do so, it would follow that the personal costs that were attached to that were undeserved. And that doesn't mean the committee must now go and overrule the judgment. It simply means that the committee will itself be satisfied that it's not an impeachable offense. Okay. Yeah, I think, Chair, I've covered. I'll just check with my team. Now, let me just tell you what we've done, just so that to go back to this thing about, you'll forgive me, this is my big bugbear, the one about the narrow approach and the wide approach. So, so how we've approached it, Chair, is we have literally, just for our own purposes, and I'm sharing this just so that you know where we are with this. Obviously, because of the finding of the committee, we have to work on the basis of that. But we have divided the charges literally into Annexure A, which is the non-controversial part, because that was the recommendation of the panel anyway. So everyone is agreed that those charges are before you. But we have created our own what we call Annexure B, which is the charges that did not meet the test and should not be before you, but they are before you. So we're going to address them. But we'll always be addressing them from the point of view that they should never have been before the committee. Sorry. Oh yes, yes. So sorry, I was misreading the note. Yes, this is apropos the so-called alternative list of so-called victimized people, and one of my learned juniors is pointing out that one of the issues, I think we also put this to. Well, we put it to Mr. Samuel, Mr. Kakana, and Ndo, and Bon, and sorry, and Bon, and Ms. Mukhalad, and that is this: that in any event, those, at least we know that not all those 7 people testified or were available, but those that we did, none of them have ever suggested to this committee that they were faced or charged with so-called trumped-up charges, which is what that sub-charge says. All of them, without fail, including Mr. Kakana. I mean, I think the master or the the king of that category is Mr. Samuel, because he was charged for actually assaulting a member of the public. So that can hardly be a trumped up charge. In fact, I think he's still facing that.
Would you share that work that you have done in terms of how you
Yes,
split
the
the
division.
charges?
Yes, we'll do that, Chair. Yes, we certainly will do that. Yeah, and even maybe with a 1-page write up, because what yes, we will, Chair. It's an exercise that we do. We simply read the report and the annexure A, and then isolated the difference. We'll definitely share it with the committee. Yes. Sorry, Chair.
Now, I don't know, there's nobody speaking, but there's a lot. I'm not sure whether you belong to Sundowns or what, but there's just a lot of
Yeah.
Okay.
No, what they want to
I'll proceed.
Thank you, Chair. What they want to do is this, Chair, is love and peace. If they want to keep their jobs. Yes, Chair, I think I'm done. Let me just make sure that, just go through my notes. Thank you for the indulgence, Chair. I know this is beyond what we had discussed as the duration of this address. Yeah, so Chair, that's the landscape. It's, as you always say, a living document or a living framework, because you can never control these things. But when there are any major changes to this framework, we will certainly share that with the members and our colleagues. The idea is really to try and do this as efficiently as possible, so that we'll address some of these issues in great detail when we do the closing argument. By the way, Chairperson, while I'm thinking about it, this is something you might want to address with the Secretariat. The what do you call it? The program, the latest program that you have sent us, and I think this was just an oversight here, does not cater for the oral arguments, unlike all the previous programs. Just someone must just attend to that here. And I don't think there was any intention to muzzle us not to do our closing addresses. I think it was just an oversight. Yes, thank you, Chair. Those are our opening remarks. Thank you very much.
Thank you, Advocate Mpofu. We are at the point that we agreed on. Thank you. I now want to turn to Ms. Fatima Ibrahim, because we're going to proceed to the witness. I've asked Kaya to check if tea is available, because you will continue talking, so you might want to take a break.
Thanks.
But if not, we'll proceed until that point. We're going to be introducing the witness, the next witness, the first of this phase. And I'm going to recognize Ms. Fatima Ibrahim to do the preliminaries.
Thank you, Chair.
Sorry, Mr. Brown. Chair, do I understand you that you just want to swear the witness in and then take a break?
Kaya, are you ready before I respond to Arvin? Okay, they're not there yet. Okay. We'll proceed. Thank you.
Thank you, sir.
Ms. Fatima Ibrahim.
Thank you, Chair. If I could maybe perhaps ask Mr. Nyathela to sit in the correct seat, we will be able to see him clearly and hopefully he's more comfortable. Good afternoon, Mr. Nyathela. Let me just see if your mic is working.
Good afternoon. Good afternoon.
Thank you.
Thank you. Just try and make sure it's closer to you or sit closer to it so that at the end, when you go to sleep, your neck is not sore.
Yeah. Thanks.
Thank you. Thanks. Thanks.
Thank you. Mr. Nyathela, I'm now going to administer your oath. Sir, you have been invited, subject to the provisions of Section 16 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act of 2004, to appear before this committee as a witness and to answer questions in respect of the committee's inquiry into the removal of the Public Protector, Advocate Mkhwebane. Please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of this inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a house or committee may not be used against you in any court or place outside of Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware further that in terms of Section 17(2) of the Powers Act, a person who willfully furnishes a house or committee with information or makes a statement before it which is false or misleading commits an offence and is liable to a fine or to imprisonment for a period not exceeding 2 years. Mr. Nyathela, I'm now going to require you to take an oath or to affirm that the evidence you are about to give is truthful. You can choose either the oath or affirmation. Which do you prefer?
Oath.
Okay, if I may please ask that you raise your right hand and repeat after me. I swear that the evidence I shall give
I swear that the evidence that I shall give
shall be the truth,
shall be the truth,
the whole truth,
and
nothing but the truth.
but nothing but the truth.
So help me God.
So help me God.
Thank you, Mr. Nyathela. Chair, the chairperson, I was going to say the chairperson is now duly sworn in. Mr. Nyathela is now duly sworn in. Thank you, Chair.
Thank you, Ms. Ibrahim. Welcome, Mr. Nyathela. I'm excited about your energy. We've always struggled with witnesses sitting there, even when they're inside and not hearing them. We can clearly hear you. So welcome, and please relax and participate on behalf of the committee. We appreciate
Thank you, Chair.
You availed yourself to be the witness.
Thanks.
I'm now going to hand over you to Advocate Mpofu to start the evidence.
Thank you very much, Chair. Yeah. Now that you are sworn in, Chair, we can start the inquiry. All right. Now, good afternoon, Mr. Nyathela.
Good afternoon, SC.
Chairperson, if I may just indicate before we proceed that despite your compliment about energy, Mr. Nyathela almost did not sleep because we were preparing him as we indicated, but he kindly indicated at lunchtime that he'll be able to proceed. So if that situation changes, I'll indicate. Thank you, Chair.
That's in order. Thank you.
Thank you, Chairperson. Mr. Nyathela, I want to start, I'm sorry, before I come to you, I just want to address the Chair. Chair, we've also just a few minutes ago received indication from the evidence leaders of which paragraphs they're not going to take much issue with. So that's the practice we've had, just so that we don't dwell too much on those issues, but we'll cover them nevertheless. Yeah. Thank you. How are you, Mr. Nyathela?
Fine on yourself, SC.
No, well, on top of the world, in spite of the difficulties. So I'm going to take you through your statement, but I'm going to start almost at the end because I want you to situate your evidence and put it in perspective in relation to this issue that I don't know if you've been following. We've been talking a lot about public participation and that kind of thing. And if I may say so, the category on which you are called really broadly falls into that. In English, there's a person called Joe Citizen.
Oh.
So we're calling you like as that person, one of the people that we found in the street. You know what I mean?
Yeah.
Thank you. Yeah. Now, Mr. Nyathela, well, firstly, what is your own view about the importance of public participation in a process like this, which involves a public institution, two public institutions really, namely Parliament and the Office of the Public Protector? Do you agree that the public should play a role in that? And if so, how would you describe it?
Yes, I do believe that the public should play a role in that, because also what is being addressed here and dealt with, it also affects us as the public.
Good. As it happens, you seem to be, well, I can tell you a secret now, that the reason that you got the short end of the stick and got chosen from the group of people that we had asked the public protector to just give us names of people who have been service is because you have yourself been, if you like, a crusader for public participation. Can you share with the committee what other, not necessarily just this issue, what other interactions you have had with this parliament, with public officials, ministers, and those kinds of people in general?
In general, I can say it's been a tough one. Not only getting no assistance or no support from this very same August House, from, I can start from the top, from the office of the speaker, to the chair of the chairs, to the chair of the portfolio committees, going down to ministers, to director generals, you name it. We've been exposed to, we've been abused. In short, I can say that we've been abused for more than 2 decades.
Yes. Okay, thank you. And we'll get to some of those issues, but for now, anyway, I think you've answered my question indirectly in that what I was getting out is the fact that you have had various interactions over what you call 2 decades at those different levels, correct?
Absolutely.
Thanks. Right. And if I may also just as part of the warm-up questions, so to speak, also ask you somewhere in your statement in one of the undisputed paragraphs, I think you have indicated that you have followed these proceedings. Obviously, they didn't listen to every witness and every word, but you've been aware that there is this process, correct?
Yes, correct.
And while we are on the subject of public participation, this committee, sometime in May, I think, or June, issued some advert for people who wanted to participate. And I don't think there was anything much more that was done to ensure public participation. Did you incidentally ever get to know about that public participation invitation?
No.
You never heard about it?
No.
Yes. And yes, and you say that in your statement, sorry, just want to see if it's contested or not, so that I know whether I can lead you. Oh. So, okay, well, let's see how it goes. You say that somewhere in paragraph 6.7, but I know that I cannot be the only one feeling this way. The public protector cannot and should not be confined to token public participation. I think it says cannot and should not be. I'll do some errata just now. Cannot and should not be confined to token invitations to comment, but must also involve participation in the actual proceedings of the committee. You see that at the bottom of paragraph 67.
Yes.
Yes. Now, I think you've answered half of this question as to why you feel passionately that public participation should be much more than just placing an advert in a newspaper. Can you comment on that?
Yes, it's important as the public to be involved and to participate that in matters that also affects us as the public.
Thank you. Chair, if I may, there are just a few typos. That was one of them. At paragraph 67, it says public protector, it should say public participation. And then there's another one at paragraph 9. If I pick any other ones, I'll indicate them. Paragraph 9 at the end of 9. So, yeah, the majority of people who get credited at the end of any movie, not none, movie or television productions are roadies of one type or another. Yeah. Thank you, Chair. Right. Now tell us then, we've already heard that you are a person of energy and a person who has been up and down these houses. So who is Mr. Nyathela? What do you do?
Mr. I'm a roadie by profession. A roadies are people who work behind the scenes. The term roadie comes from an industry jargon that denotes people who are always on the road with musicians, setting up stages, lights, sound, etc. So I started as a roadie in the early 80s with a top South African band called Harare, and also working with Sipho Hot Sticks Mabuse, his solo career. So I was fortunate to be working with Harare. Harare was the first Black group to own their technical equipment. So I had access to the technical equipment, and then I had the privilege to travel around the country, including the SADC regions, doing our own tours and concerts with Harare and Sipho Hot Sticks Mabuse.
Thank you. And now I'm going to talk about roadies as an industry. You are, and this is not disputed, the president of the South African Roadies Association.
Yes, I'm the president and founder, of the South African Roadies Association, a non-profit making organization dedicated to the training of young people to acquire technical and production skills and opportunities.
Thank you. And well, it's not disputed that the South African Roadies Association was an idea conceived by you in 1992 for giving young people career prospects in the entertainment and business, and equipping them rather to entertainment, technology and business, and equipping them with the necessary qualifications. And you say at paragraph 6, this arose from your observation of the skills gap and racially skewed nature of the availability of relevant skills, as well as training and development opportunities in the sector. Can you just expand on that? In other words, what was the fire that drove you to form this organization?
Yes, thanks, Essie. Essie, the whole idea came about before 1990. It started coming to me around 1984, 85. And then what really struck me, it was the imbalances in the sector that we, as Black people, we were deprived of acquiring technical and production skills. We were only relegated to be equipment porters. That's why I said before that I was fortunate. I was one of the few fortunate people to have worked with Harare, and Harare having its own technical equipment. And then only, again, the imbalances, they didn't stop only there, but they also went as far as the venues. You go to formally white venues, you walk into a hall, you look at the stage. It's got a backdrop, it's got 2 or 3 lighting bars, it's got a permanent PA system, to extend also that it also have some mixing desk, like a mixing console for lighting, for stage. But you go to our communities, in our halls, you look at the stage, it's empty, not even a backdrop, not even one light, so that you, as Black people, you mustn't see that a sector or be exposed to that industry, so that you cannot dream to even get involved or try to participate. So that really struck me. And then the other thing that I won't forget, it was in early 1985, was setting up a Durban City Hall. When was ready now to lift the speakers on top of the stage. And then a white gentleman said, no, 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 you don't have to do that. Just put it just nearer the stage. And then he went at the stage and then just pressed the button, and then the stage just raised above. I was like, sure. And then after the sound check, waiting for the band to do the sound check. I was sitting there thinking that, yo, and then thinking about where I come from, the hall in my township, Orlando West, Uncle Tom's Hall, that's empty, no sound, no lighting desk. Said, yeah, no, this system, it's so deep, and then something must be done. But I could not start it by then, because if I dare it started, I would have disappeared.
Yes.
That's why I had to wait for 1992, the banning of the release of political prisoners, and then started the journey in 1992.
Thank you. Thank you very much. Yeah, feel free to just express yourself as you wish. Now, right, so now the organization is formed, and we know, I think you've expressed passionately what drove you to form it. And this is now, and you've also explained my next question, which was, why was it particularly formed after 1990? And I think you've covered that. Now, so you formed the organization, and we're now going to the stage where we're building up to where you would interact with the Office of the Public Protector at a later stage. But can you share with the committee then your, shall we call it, struggles and endeavors which led to the formation of ties with international associations? Again, this is the undisputed part of your evidence. So I'm kind of covering many things in one long question. And maybe I can prompt you by reading paragraph 7 and 8, where you say up until 2004, the association just had a single room, and it was only with the support of the National Lottery and French Embassy that this is now 12 years later, sorry, in 2004. A building with enough space for several classrooms, administration offices, and the storage area that could be purchased in the new town area of Johannesburg, especially in Henry Ngumalo Street, a stone throw from the famous Market Theatre. We'll come to that. That's the next stage. I want you now to address what is at paragraph 8, which is when you said when they complete their training, many young graduates from your outfit work all over the world. Currently, some of them can be found in places like Dubai, USA, and all over South Africa in broadcasting, music, and the film industries, to mention a few. Now, these products of yours, which is what we call graduates, the people who come from the institute, according to your statement, came as a result of, shall we call it, you're knocking at doors and forging international networks. Can you take the committee through that?
Yes. Starting point is that we started to request for assistance here at home. Unfortunately, doors were shut on our faces, even from our own African Black people. Doors were shut on our face. And then we started looking outside the country. And then the first people that we engaged were the Irish, because of the history of their history, especially how they built their music industry. And fortunately, they welcomed our proposal. And then in 1996, they sent one of their industry experts on a fact-finding mission. to find out about SARA and its status in the South African entertainment industry. After this visit of Mr. Kit Donald, he wrote a report with some recommendations. And one of the recommendations was that there was no training in this field in South Africa, and a trainer must be found in Ireland to come down to South Africa and deliver a 3 months intensive course in live sound stage production. That happened in 1997, and the following year, the Irish sent a trainer who stayed with us for 5 years, training and also delivering the trainer aspects. And 97 hooked up with the Ministry of Education, Culture and Science of the Netherlands, after meeting the advisor to the Director General of the ministry. In Grahamstown, there was a conference around August 1997. Its theme was the economic benefits of arts and culture. So I met with this advisor to the Director General of the Ministry of Netherlands. And then I asked him if he could hook us up with one of their biggest promotion company called Mojo Concert. So he was surprised that I knew about Mojo Concert. And then he said, no, when I go back, I'll try something. Same year, around October, received a fax that the ministry is willing to support, and they've roped in Mojo Concerts. Mojo Concerts are also the owners of North Sea Jazz Festival and other big festivals in Holland, like the Lowlands Festival. And then we got this fax around October saying, so now tell us in which areas will you like us to assist? And then we said production, because we knew that the Dutch were good in production and the Irish were already assisting us with sound. And that's how it started. 98, 3 Dutch production professionals were sent to South Africa to deliver a 1-month production course, Helicopter View, and then followed by the French through the French Embassy and the French Institute, and then we requested them to assist in lighting, because we knew that the French were also good in lighting, and they obliged. And every year they were sending a trainer, both the Dutch and the French, sending trainers to South Africa to train our young people in production and lighting, and then also hosting our students in Holland to participate at the North Sea Jazz Festival, hands-on training at the Lowlands Festival, and then the French in some of their events and also venues, and then came the British through the British Council. They sent their technicians to train our young people in to be backline technicians. Backline, we're talking about those instruments that you'll see on stage. So that's how we managed to build this international network. And then also 98, I was invited to the UK by an industry as one of their industry associations called PSA, Production Services Overseas. And during all this time, not a single cent was like coming from home, even for students' trips or my personal trips to these countries were paid by this foreign countries. So in 1998, I attended one of the industry trade fairs called Plaza Show. It's an annual event. It's held in the UK where the latest technology equipment is showcased, and then there are also educational seminars there. So there I met with the technical manager of one of Europe's largest, North Europe, largest music and art festival called Roskilde Festival, which is in Denmark. They made a commitment since 1999 with sending 4 students to Roskilde. That happened for more than 12 years. Every year, around June, we'll send 4 of our students to participate at Roskilde. That's why also the only existing qualification titled Live Event Technical Production, it was championed by the South African Roadies Association.
Thank you very much, Mr. Nyathela. That's quite a journey around the world, which we've taken in a few minutes. You've also mentioned, I think it's paragraph 13, that you had similar contacts as part of your network in Denmark. I think you've mentioned Norway. Is that correct?
Yes.
And would those also have been part of this, shall we call it, network building, where you wanted to benefit particularly young Black talent in this field?
Absolutely, SC, because the other thing is that even in our country, our young people were deprived of opportunities, even in government-sponsored events, like your National Day events and all of that, because most of the suppliers, technical companies, were that are getting these tenders to provide these services are white-owned companies. It's only now, recently, that Black-owned companies are coming. So most of those white-owned companies were very, very hostile towards education and training, and then supported by our own people. That's unfortunate.
Thank you very much. And so all in all, before COVID, I know that at some stage you say COVID kind of disturbed the flow. But let's say just before COVID, say around about 2019, 2020. By that time, how far was this network and how many young people were you able to send, averagely, to send out to various parts of the world?
I can say to date, hundreds of Black kids who are involved in this industry, graduates, you find them everywhere. Even, like I've said, in most of these companies, in broadcasting, even internationally, in the some are working in Dubai, some currently as we speak are in Qatar, 6 since they left in February. They are in the States, touring the States for 10 months with Universal Circus, the only African American circus. And then that relationship with the circus started in 2002 and it's still continuing until today.
Thank you. Okay, before I ask the chair to appoint you as the Minister of Arts and Culture, can you just tell us specifically of the relationship with the US company Universal Africa, because that's what leads us to your first complaint to the public protector. Sorry, Chair.
Yeah, we will, after his response, take a break for tea for 15 minutes, but please respond.
Okay. I had to start it where it started.
Chair, maybe we should take a break now. I can tell you now.
Well, I'm guided by you. Thank you. We'll take a 15-minute break and be back at quarter to. Thank you.
I won't say what is happening now.
Recording stopped.
From the tea break, we continue with the leading of evidence by Advocate Mpofu. I therefore hand over to Advocate Mpofu to proceed and continue.
Thank you, Honorable Chair. Yes, Mr. Nyathela, I stopped you when you were about to answer the question I had asked about your first encounter and relationship with Universal, what's it called? Universal Circus.
Yeah.
Which you described as the only Black led American circus. How did you get to meet them and what was the nature of the relationship or what it still is now? If you can just take us through those steps.
Okay, Universal Circus came to perform in South Africa in 2001. They were performing at Gold Reef City. They had a space there because the circus performed under a big tent. So they had a space there. And then one day was listening to the radio, Kaya FM, and then I heard the interview of the founder and president of the circus, Mr. Cedric Walker. And then as I was listening to his interview, I could hear that, hey, this gentleman is talking our language. So I called Gold Reef to ask for their contact. And then they said, no, just call in 10 minutes, call back in 10 minutes, and then we'll give you their production office number. I did that, I called, and I got the vice president of the circus, Paula, and then I told her about Sarah and its activities and our wish to meet with Mr. Walker. And
just before you proceed, or you want to kiss it? We don't want you to kiss it, but it close but not kiss it.
Thanks.
Thank you.
Thanks, Chair.
Thank you, Chair.
Yeah, and then they promised to come back to us, and a week before the circus show ended, I got a call that no, Mr. Walker who agreed to meet with me. I went there, we met and briefed him about Sarah, and then he was surprised that there was an association of roadies, also that Black Roadies Association, even running training programs. And then he said, no, for me, I'll make one commitment now on the spot. Every year when we tour the States, Freddie, I'll take some of your kids to come and tour with us. October 2021 got a fax saying, no, would like to have 22 of your kids to come over to the States in.
So sorry to cut you. That year was, they said 2021. That
2001.
2001.
2000, okay. Sorry for that.
Okay.
And then 2002, they took 22 of our kids to go and tour with them for, they were running 2 tours. So that's 11 per shows. They were running 2 shows. And then for 10 months, getting paid, everything paid by by the circus. And when they came back, some of them even bought houses for their families. Some bought equipment to start servicing their communities, weddings, etc. And then that continued 2002, 3, at the end of the tour of 2004, they requested that if we can raise funds for the return air tickets for our students, and then they'll still cover all the expenses, including the visas and wages on the state side. So and then that year, late that year, we submitted a proposal to the National Department of Arts and Culture for the payment of 16 return air tickets. And the department made verbal and written commitments that they will fund the 16 return air tickets. Because the other thing that we were not asking the department to give us the funds, but they could even pay the travel agent directly for the 16 return air tickets. Unfortunately,
okay, so before we get to the unfortunate part, can we just for the sort of take the committee with us, can we go to annexure FN1? I just want to confirm that what you've just said about was this the letter is addressed to you, dated 28th October 2004. Is that the universal logo?
Yes.
And let's just go to the letter. The second paragraph. Well, the first paragraph said is we actually hire and train young people from around the world, and members of SARA have consistently outperformed many of them. The initiative, enthusiasm, and professionalism they possess is unparalleled. You are to be commended for the training and leadership you have provided the members of your organization. And then we would like to extend the opportunity to place approximately 30 of your students next year at salaries of $350 to $650 per week. In addition to the normal training areas, they will have an opportunity next year to be exposed to film and video production. The Universal Circus will provide training and salary, transportation, and lodging stateside. We will need you to provide air travel from South Africa to Atlanta. Is that what you just told the committee about? That offer, provided you provide the air travel, which then brought you to the department?
Yes.
Right.
Absolutely.
Now, you were at the point where you were saying that you approached the department, they made verbal and written undertakings, and unfortunately?
Yes, unfortunately, what transpired, it was that I got a call 5 hours before departure. 16 young people were already there at Sarah House with their bags ready to travel. Then I got a call around 2:10 in the afternoon. The departure was 8 p.m. And then the junior official started by saying, "Hey, Bra Freddie, I don't know where to start, but I was informed that I must tell you that the department can no longer fund this project. I could not believe it. It really, really struck me. It was just unbelievable. And fortunately, the following morning, the travel agent, which was a white woman, Marilise van Rensburg, said, Freddie, this cannot happen. I will release the tickets. The young people must go, and then we'll make some arrangement. How will you pay back the money? That's how that project and the young people managed to travel. It was very, very, very sad.
Sorry. And this then, you were saying with your troubles with the Departments of Arts and Culture, you then approached the Office of the Public Protector at some stage. Am I correct?
Yes, you're correct.
And who was the Public Protector at that time?
It was Advocate Lawrence Mushwana.
Right. Okay. Can you then tell the committee about your experiences in the Public Protector's office under the leadership of Advocate Mushwana, as far as you are concerned?
Yes. What happened? It was that the investigator was doing her best, not taking sides, doing her job perfectly. But the problem started when Ms. Ponatsejo Mokhaladi came into the picture. And what happened is that we ended up having an ADR meeting, and then it was chaired by Ms. Mokhaladi.
So what will be ADR meeting?
Yes. ADR.
Alternative dispute resolution.
Yeah.
Yes, thank you. Yeah. So,
Yes.
yes. Yes. No. I was also going to explain that. In other words, under the aegis of the Public Protector's Office.
Yes.
As one of the solutions. I think one of the witnesses explained the different methods here. Thank you, Chair. Okay.
Advocate, pause, Mr. Nyathela.
Sorry, Advocate Mpofu, am I correct? We're dealing with paragraph 27 onwards. There isn't a written application attached to the papers, am I correct? There's a reference to submitting an application. I'm just checking that I haven't missed something. There isn't an application.
No, there isn't. Yeah, submitting a complaint. I think that's what I meant. Yeah, it's not. There's no. We haven't attached anything in this paper.
I'm referring. There's a reference to an application for funding to the department.
Oh, I see.
I'm just checking whether there was a written application on the papers or not.
No, absolutely not. Thanks. Oh yes, yeah. Sorry, we're at paragraph 27 now. But Nyathela, sorry, in this section, I'm not going to lead you as much as I did before on the admitted parts, but so you have to give us evidence. I'll try and lead you, and I'll be stopped if I'm overdoing it. The application that you refer to there, when and where did you submit it, to whom, and yeah.
It was submitted to the Department of Arts and Culture on their own template as we were engaging. And yes, that's it.
That's okay. No,
Yeah.
that's good enough. Thank you. All right. Then, okay, you were the chair and I interrupted you when you were saying that the process was then taken to ADR, and then what happened?
Yes, chaired by Ms. Mukhaladi from the Public Protector's Office. And then after that, a report was issued. But I had issues in that meeting with, that's where it started between me and Ms. Mukhaladi up until today, whereby I was questioning Ms. Mukhaladi about her biasness in terms of handling the meeting. And I even said to her that it's if now you have turned into a spokeswoman of the department. And then I could see that she didn't take lightly of that. And then when the report came out, it stated that there was no written commitment from the department side, whilst there was some written exchange of communication between us, Sarah, and the department. And then the report exonerated the department in terms of not funding for the 16 return air tickets, but there were also recommendations that the department must make sure that we get assistance in terms of our international projects and also some funding support for admin and operations, including assistance for the renovation of our building. And then,
good, yeah. Thank you. Okay, then we will come back to that report. But if you can just tell the members about this building that you wanted to be renovated. Where was it? What was it for? What was wrong with it?
Yes, when we started, we operated from a one-room office with only one line, using it as a fax and telephone. And then around 2003, another gentleman by the name of Mr. Zikwe Msimanga introduced me to the owner of the building, which is just near the Market Theatre. It's got a huge space, enough space for training, even classrooms and admin section. And then the owner was selling it for around about 5 million. But when he heard about what we are doing, he said, oh, for you, I can give it for 1 million. And we made an agreement and signed what you call purchase agreement and all of that, and a lease for 1 year with an option to buy it. And then we signed the document and submitted an application to Lotto. It was rejected, resubmitted it, and they finally called me for presentation. And then it was approved, 1,400,000 and couple of rands, and the French, through the French embassy, contributed around 600,000, even on that note, after the lotto is approved, but still they didn't want to release the funds, they were sending their people to go behind our backs because they already had the contacts of the owner. So they sent people to the owner to say, hey, we can give you 5 million. These people are delaying you with only 1 million. And then it came to me, Dr. Pani, how it said they have been approached by people saying this and that no, Lotto is not going to give you the money. And then I showed them the confirmation letter from Lotto that me, I am not in a hurry. I'll wait until Lotto gives the money. We had to do a sit-in at Lotto for Lotto to release the funds. So that's how the funds were finally released, and we paid and we moved into the building in January 2004.
Right. So I take it then going back to what you had said in the Public Protector's Office, that I can take it that the building was not in a good condition and you then wanted government assistance for its renovation, as you previously testified, correct?
Absolutely. And then because we even submitted a proposal to the National Department of Arts and Culture for assistance in terms of the renovations.
Right. Okay, so those were your side of the proposals in the ADR, and what was agreed?
Yeah, it was agreed that we will meet with the department, and then because the department said they don't have the funds to give us for the renovation, but they will liaise with the relevant stakeholders who are funding for infrastructure and renovation and help us get that support. And then they will provide support for our admin and operation, and also fund for our students international trips.
Right. Okay. So those were, shall we call them, the milestones of the Mushwana era.
Yeah.
You said you had the negative experiences with the report, with the attitude of Ms. Mkhaladi, but at least there was this agreement or regarding renovations.
Yes.
Was the agreement honored?
No, it was not honored. And then when the new public protector came in, meaning Advocate Madonsela, we approached her, and then he delegated that our complaint to her deputy Advocate Malunga, who handled the matter. But still, our complaint was still under Ms. Mokhaladi as the executive manager in the office. And we finally reached a settlement with the department, that was signed by the department, Sarah, and public protector.
Yes,
that was in 2014.
Yes.
Yeah.
Yes. Can you go to FN3? Maybe, sorry, maybe for the sake of progress, can you start at FN2, Tsepo? Right. Is that the public protector's report that you are referring to?
Yes.
It says report on a complaint of Mr. Nyathela on allegation that the Department of Arts and Culture reneged on an alleged undertaking to provide funding for the South African Roadies Association.
Yes.
And then it's got the heading and report number and so on. If you can just go to the last page of that, just so that we can locate the date. Right. And it's dated the 6th of July, rather the 25th of July, 2006.
Yes.
Is that the report and signed by Advocate Mushwana as you've testified?
Yes.
As the public protector. Okay. Now, FN3. Right. Just show us the whole page. And that one is headed settlement agreement in terms of section 64D of the Public Protector Act of 1994, involving a dispute, South African Roadies Association and the National Department of Arts and Culture. And the heading is Final Settlement Agreement 1 April 2014. Is that the date you were
yes
referring to? Okay, right. Okay, you can, yeah, I was just dating the where you were. What then happened next?
What happened next? The department failed to implement its commitments regarding this settlement agreement, to the extent that the department officials even came to Parliament, to the portfolio committee, and even willfully presented dishonest statements to the portfolio committee regarding the implementation of its commitments as per this settlement agreement. And then to add on that is that, I don't know, see if I can continue on that, because that also led us to file the first complaint against the department's officials to Parliament regarding the officials of the department willfully presenting dishonest statements to the portfolio committee.
Good. And all right, after that, then what were your other experiences, let's say, in the Advocate Madonsela era of the Public Protector's Office?
No, it took long because we even I requested for her intervention, and unfortunately, the department was treated with kid gloves at our expense, and this matter dragged on and on and on without any closure, and until Advocate Madonsela left. Because the other thing that I can mention is that I've never met with Advocate Madonsela, but I once spoke to her on the phone because she called me after I've been trying to, meaning reach her to say, hey, there is no movement from your office in terms of helping us to make sure that the department do comply with its commitments.
Yes. And have you ever met with the other previous public protector, Advocate Bushana, or have you also not met with her?
No,
With him, sorry.
No, I never met with him.
Never met him. Right. And so am I to understand therefore that this matter started from the what we call the Advocate Mushwana era, and as you call it, dragged on through the entire period of Advocate Matonsela's 7-year term?
Yes, this matter dragged on for almost 11 years. It was testing. It was frustrating. There was no movement. I could not believe it. That why will, especially our people, as Black people, why will we be against the empowerment of the child and those not yet born? Why? Why do you play the man instead of playing the ball? Because this is not about me. This is what I've been saying from day one. This is about the child. This is not about me. But it kept carrying on and on and on. That's why it has to take 11 years for this to be resolved.
Sure. Thank you. So, all right. Well, we've heard about backlogs in this inquiry, but we didn't know that it could go as far as 11 years or span through and 3 public protectors at least. So, and if the complainants here have their way, it will even get into the 4th one once they apply the chop. So anyway, so the let's call it the Matonsela era. You've then explained that literally it went through the entire 7-year period and more. We will, I think, start with the next segment in that evolution next in the next session. So I just want to round off some of the issues that you have covered now. Am I correct? And excuse me if I make you to repeat something that you've already covered, that in the Advocate Matonsela era of this matter, your file, for lack of a better word, was still being handled by Ms. Panatsago Mokhaladi.
Yes, she was the head of the investigators. They were reporting to her. And then in most cases, she'll be part of those meetings and she'll be the one who will be chairing those meetings until when the PP Advocate Matonsela said no, let the PP deal with this matter. That's how it was moved to Advocate Malunga, because there was no movement from the side of the investigators and any decisive intervention or assistance from Ms. Mokhaladi.
Right. And well, you have said that you were unhappy, obviously, with the services of Ms. Mokhaladi, correct?
Yes.
And one can say, having listened, I put to her the issue of complaints, and you raised, I think you've already covered this, you raised several complaints about the lack of progress, correct?
Yes.
Yes. And I put to her the your complaints as an example of some of the, shall we call it, lethargy that would have been associated with some of the work she was doing in that relevant period.
Okay.
Sorry.
Just a pause at Redimboff.
Yeah, I'm going to object to the way the question is formulated, because effectively what was put to Ms. Mokhaladi was put in one line, was a reference to Mr. Nyathela, and there was an answer, and then Advocate Mpofu went on to another complaint which wasn't related to Mr. Nyathela. So what wasn't put to Mr. Nyathela, sorry, to Ms. Mokhaladi, was what Advocate Mpofu is now representing to the witness was put. And I'm happy to go to the transcript if we need to do that.
Yeah.
But I'm objecting to the
Okay.
the way the question has been formulated.
Okay, thank you, Advocate Mpofu.
Thank you, Chair. No, I think that's an easy objection to deal with because it's preemptive. I've not said anything about what Ms. Mokhaladi said. I've simply said that I was questioning her generally about complaints. That part is true. And it was in that context that the name of Mr. Nyathela arose. And Advocate Bauer is quite correct that I cited it as just one of the examples there. We didn't have a long discussion about the ins and outs, but the topic I was busy with her about was complaints in general. And she said, no, I think she first said there have never been complaints against her. Then I gave her one or two names and she considered that's as I remember it, but I stand correct.
Yes,
Chair, I am going to say that it was Advocate Mpofu that offered the name of Mr. Nyathela and not Ms. Mokhaladi.
But that's what I've just said.
A mistake. I just want to make sure that you and I are not on the wrong page.
No, okay, thank you. Chair, sorry, I also don't want to be on the wrong page with Advocate Bauer. Let me summarize again how I remember it. I was questioning Ms. Mokhaladi about complaints against her. And she said there were no complaints against her. Maybe I'm putting it too strongly. I then said, what about, I can't even remember whatever the other example is. And then I also made an example of Mr. Nyathela. And that's what I'm getting into. I'm not putting it any higher than that. Are you happy with that? Thanks.
Okay. Proceed.
Yes, whatever the question was, and I'll agree with Advocate Bauer's version of it because
you can switch on your mic again.
Yes. Now I'm saying whatever the question was, but the answer that I received was that Mr. Nyathela, something to the effect that Mr. Nyathela likes to complain. Okay, maybe let's do it like this so that I don't, sorry, I'll do it like this. Let me not put the question, let me ask you the question. Did you watch the evidence of Ms. Mokhaladi?
That's where I wanted to go to, AC.
Yes.
Because when I heard that Ms. Mokhaladi will be testifying, I made it a point that I'm going to listen to this setup. I can, meaning recall exactly you were asking her about the question, the complaints. And then that's when you said, no, we'll bring a witness here. And then Mr. Nyathela. And then her response was that, yeah, no, I know Mr. Nyathela. Mr. Nyathela likes to complain. And then when I was sitting, I said, hey, there comes this woman again. Here comes this woman.
You mean Miss Mokhaladi?
Mokhaladi.
Here comes Miss Mokhaladi.
Exactly.
Maybe just take away the woman thing.
Sorry. No, she is not an insult. She is a woman.
No, not in that way.
Not that way, yes.
Yeah, thank you. Switch on your mic, continue.
Sure. Yeah, it would be, I was going to say, if she was a man, it would be a demotion.
Yeah, no, apologies. Yes, that's how it came out.
Okay, just a pause.
Sorry,
Advocate
there's a,
Mpofu. Advocate Bauer.
So that Advocate Mpofu and I'm on the same page. This is the exact wording from the transcript. Advocate Mpofu said, "Do you know, Mr. Nyathela, we used to complain about you a lot." Ms. Moghaladi said, "Correct. Mr. Nyathela complains a lot. Mr. Nyathela complains about almost everyone who handles his case in this organization and everybody else." Just so that the record is clear.
Oh,
on
thank
what
you.
was said.
Thank you. I think that's the accurate. But you were saying anyway, when she said you complain about everything or whatever has just been said, you were taken aback. I think that's where you were.
Exactly. And then I could not understand it, that the whole, what do you call, executive manager at the public protector's office is saying that Mr. Nyathela likes. Is there anybody who likes to complain? No. We go to the public protector to file a complaint because we've got evidence. We understand evidence. Our work is development. We are not in the business of smear campaigns or lying about people. We are for development. When we complain, we present evidence. That's it. We are in the business of youth empowerment. We don't have time for to just wake up and just complain. No. And then that office is for us, because some of us, we don't have the deep pockets to go to court and litigate. That's our last hope. That's why we go there to that office. And then we're not going to that office to ask for some special favors or some special treatment, because we were not brought up like that. And Sarah was not built on favors or special treatment. It was built through sweat, hard work. Thank you.
I think if you let it get hotter than that, it might burn the building again. So if we can, Chair, as I indicated earlier, that Mr. Nyathela had a, shall we call it, an early morning, and I had informally indicated that I would prefer to cut it at this point, because the next session is going to be about the, let's call it the Mkhwebane era and his experiences at that point. So it would, Chair, it would be an appropriate time, if you so please, to break it at this point.
Okay. Thank you, Advocate Mpofu. So there would have been a request about not pushing it to 5 o'clock with the witness. So you wanted to end it at that passion point. Okay. No, that's fine. Thank you, Advocate Mpofu. Colleagues and everybody in the meeting, that's where we're going to pause for the day and resume tomorrow to continue with the next section of that has been mentioned. So the plan is not to mix Advocate Madonsela's era and Advocate Mkhwebane's era. Thank you very much. So, Mr. Nyathela, we'll pause there and see you tomorrow morning as we'll continue. Thank you very much for the day, and thanks to all of you colleagues. That's where we'll end it. See you tomorrow.
Thank you, Chair.
Thank you. Chair. 10. That's what is in the program. Thank you. Thank you.